satisfaction from my lord. All these matters, at least from 3 to 9, I can vouch for. All these matters are completely different. One is completely different from the other. The blanket submission that has been made regarding the GST tribunal.
No. I have asked him to give a synopsis of what are the different matters.
Malad, may I?
To the GST or not at 11. At 11, let Mr. Mishra come.
Malad. Very grateful.
3 to 9. 3 to 9.
I am for the petitioner, my lord. Petitioner is praying for interest on delayed payment of arrear pension, my lord.
Yes.
My lord, I am led by Ms. Supriya Singh. My lord, standard order.
Affidavit of service.
My lord, I will serve that today, my lord.
Service are completed. Lord advocate for the petitioner. Why haven't you completed within this period?
My lord,
Yesterday also this
lordship
matter was taken up.
directed to reserve the copy to the state, my lord. That's why.
Only state is the respondent.
My lord.
NHI.
Serve upon the respondents. It is second up in all. Serve upon the respondent and file an affidavit in the second up. This will be taken up at 2 p.m. Pass away 2 p.m. In the meantime, you pause service and file the affidavit of service at 2 p.m.
Eleven, my lord. We appear for the respondents, my lord.
What is the application?
My lord, 11, Mr. Bikash Bhattacharya is appearing, my lord.
If my lord,
What is this application for?
this can be taken up next week again, my lord, because just received the brief. There's a restoration application.
No, restoration.
What can one?
No, 10-1 restoration.
No, there is no other application. Can one is the only application.
Only one application. My lord, put the necessary order, my lord.
And one and one. Come up with the can one also. Restoration of this application means.
Restoration.
It's not the covering letter says restoration, that is why. It's not a restoration application, my lord.
Who is for NHAI you have served?
Mr.
NHAI? NHAI you have served?
Sir, my lord. My lord,
What is your affidavit?
my lord, in earlier occasion is appear, my lord. To one occasion she is appear, my lord.
No, the copy of the application has been served.
But can one the state has?
Can one only state has, my lord.
Lord, I am for
this is a...
My lord, it's
Mr. Bhattacharya, this CAN application has been served upon NHAI.
like my junior there can not supply the information.
Because he has not prepared any affidavit of service.
my lord, I have affidavit of service, my lord.
You just check whether it has been served or not.
My lord, I have served all. My lord, in CAN application only state has been is party, my lord.
No. Opposite party number 3 is the NHAI.
No, it about the time.
Lordship, on behalf of NHA, Lordship,
You are for NHAI?
I am petitioning Lordship. I take executive to Lordship.
My lord, on behalf of the state also, my lord, my prayer is subject to your lordship's.
Accommodation, but like in the meantime, they should not take any adverse action. That's the only appeal.
I've just got the brief, my lord. It should not be a ground, my lord. But I am also requesting my learned senior friend to kindly appreciate the situation we are in, my
No,
lord.
I
If
appreciate.
your lordship can kindly take it up on 17. I know sir never refuses, my lord.
No,
So I am just asking till 17.
Let
Till
it be on
17 subject to
17th or any
lordship's
other day,
convenience, my
but
lord.
in the meantime,
On
NHAI
16th.
should not take
16.
any adverse action
16,
against
very
it.
well. 16.
Affidavit of service filed on behalf of the
16.
petitioner is taken on record. Mr. Kunaljit Bhattacharya, learned additional government leader, as well as learned advocate for NHAI, seeks accommodation. Release this matter on 16th.
Great, my lord. 16, my lord will be there.
No, but only
Later,
the,
immediate-
This prayer is prayer.
in the meantime, no adverse action should be taken. They have tried to by force.
Right. My lord, NHI must be taking. I don't know who is taking.
Yes,
is taking.
NHAI. The status quo as of date be maintained, I don't mind.
If your lordship directs the NHI, my lord, restrains the NHI, my lord, I have nothing to say.
Yeah, that's a simple prayer. I'm not going to make any further prayer. Let it them take time.
Mr. Vikas Ranjan Bhattacharya, learned senior advocate, appearing through virtual mode, submits that the officers and authorized persons of the NHAI
Yes.
is trying to remove the soil / sand dumped in front of petitioner's shops.
No, on the contrary, they are dumping that to block
Who?
my ingress egress. They let them not do anything further.
Let it come up, because interim order will not be necessary. Let it come up on the 16th.
Yes.
But if
We
in the
can
meantime
decide.
They start doing the further adverse situation, then I'll be out of court.
My lord,
I
it's,
don't think so.
it's an infrastructure,
don't-
infrastructure
Let it be
project, my lord.
understood. Let the council will not understand this and communicate to his authorities. Then let them not take any further adverse action.
Okay. Authorized persons are dumping soil and sand in front of petitioner's shops located at Chaparir Pad 1 and 2,
Rasta
Gram
banano to.
Panchayat, Alipurduar Block 2, District Alipurduar. He seeks that till the application is being finally heard, a status quo order be passed.
My lord, may I be permitted to interrupt your lordship,
Yes.
my lord? Will kindly record one submission on mine, and that this is an infrastructure project, my lord. And a staying of an infrastructure project, my lord, has
Oh,
a greater
God.
remification, my lord.
Infrastructure project.
So,
Three,
shooting
4
out the
days.
citizens'
my lord,
right.
infrastructure project, kindly will record my submission, my lord. In
Mr.
respect of
Kunal seeks accommodation, he
infrastructure.
submits that.
Judge,
Mr. Bhattacharya submits that the infrastructural project of building of road,
roads, my lord.
building of road has been undertaken, and any interim order would hamper the further construction of the road. Mr. Bhattacharya, Vikas Ranjan Bhattacharya submission आगे रख दें। सिक्स की बोलना बोलो विकास रंजन भट्टाचार्य रेट है in considering the submissions advanced on behalf of the petitioner,
Dr. I appear for the National Highway Authority.
parties are directed to, yes, parties are directed to let a status quo be maintained in the meantime. Release this matter on 16th.
16th. Wait.
Yes.
16th.
Deeply
Till 16th, status quo order is passed till 16th. On 16th, the matter will be taken.
Lordship. Obliged.
Mr. Das is appearing for NHAI.
I'm appearing for the National Highway Authority of India, Lordship.
Okay.
Where the effective respondent.
And status quo order is passed till 16th. On the 16th, the matter will be taken up.
Deeply
Obliged.
Okay.
Madam, I'm appearing for the petitioner, my lord. Am I audible, my lord?
Which item?
Item 12 and 13, my lord.
12 has not been called.
Item 12.
Madam, I am appearing for the petitioner, my lord.
Yeah,
Am I audible, my lord?
who is for? Yes, who is for the municipality?
Lordship, Mr. Pritam Das will appear in this matter for the municipality. He is suffering from high fever, Lordship. Kindly praying for 2 days accommodation.
What is this? Due is there? Periods of payment?
My lord? Yes, my lord, yes, my lord.
Accommodation is sought for on behalf of Mr. Pritam Das, learned advocate representing respondent municipality. Which municipality is this?
Mal municipality.
Mal municipality, my
Mal
lord.
municipality.
Mal municipality. 18th, you know. Next week on 18th. 18th.
Grateful, my lord.
18 now.
Next.
And for the petitioner, my lord. Yes, my lord, similar matter.
Same matter.
Petition. Same order. 18th.
Grateful, man, grateful.
The 14 lords may appear for the writ petition, lords. Lordship, this is an application. Lordship, mother of the petitioner was an assistant primary school teacher, lordship.
Means that service. Service.
Lordship, my learned junior is there.
Service.
My lord,
Nobody is here.
My learned junior is there for
Lordship, I don't have the service, evident service copy right now.
The service has
I
not
will
been
serve the
affected. There was a
copy,
direction.
By next day.
Lordship, a kind fixed on 17 lordship, 17 June lordship. As per your lordship convenience.
The question is why this has not been, then you have mentioned the matter without completing the service. There was a direction to serve copy.
Lordship, there
Service
is
has
a-
already been completed, Your Lordship. We have not.
The advocate for the petition seeks accommodation to file affidavit of service. 18. 18.
18th. 14.
None appears on behalf of the petitioner.
In item number 15. Lordship, I am appearing for the respondents. This is the service matter of the SSB, Your Lordship, and it is.
None appears on behalf of the petitioner. Your service appearing for?
All the respondents, SSB, Your Lordship.
Respondents are represented. For reasons of justice, the matter is adjourned. 18th. Gives this matter on 18th. What is the prayer? Sure. 18th. Tera.
She's dying for the petition.
Yes.
My service.
But I appear for the state. My lord, I appear for the private respondents.
Lordship, may I, Lordship? Lordship, the petitioner, he is a seller of eggs. He is continuing his business for the last 30 years. Now, all of a sudden, Lordship, he has all the trade license, Gram Panchayat tax, everything, electricity connection in his name. Lordship, he is continuing his business for the last 30 years. There is no doubt about that. Now, all on a sudden, if you, Lordship, kindly directly come to annexure P3.
E?
P3, that is at annexure page 28.
30 দেখুন
28.
আমাকে যেটা দিয়েছো
This letter is dated 18 February 2019. Addressed to who? Muhammad Nizamuddin. I am not Nizamuddin. I don't know who is this person, but I was delivered this letter saying that if your lordship takes the body of the letter, in order to comply with the order, the Honorable High Court in respect of WP such and such, and to remove the structure as per relevant provisions of the Highway Act. Lordship turns the page. This is the order of the executive engineer. The next page, next letter at page number 30, they have found encroachment in front of our land and structure. This is the complaint made by the private respondents. And lordship turns to the next page, page number 31. This is the order that was passed by the Honorable High Court. Nobody appears on behalf of the state respondents. Mr. Chondi Chorande is requested to appear on behalf of the state. A copy of the petition is served upon him. The grievance is that encroachment. Lordship turns to the next page. In view of the submissions of the state, W is disposed of by directing the Assistant Engineer, North Bengal Construction Division, Ilkat Road, to consider the petitioner's representation, a copy whereof is marked as annexed P3 for the petition in accordance with law, and communicate a decision, communicate a reasoned decision to the petitioners within a period of 8 weeks of service of a copy of this order. The Honorable High Court directed the state respondents to consider the representation of the private respondents, afford opportunity of hearing, and finally dispose of. Now, pursuant to this order, the proceedings at page number 31 was 29 was drawn, and ultimately I was handed this letter, which is at page 28. 28. That in order to comply, that first page 28, Lordship. Pursuant to that order, pursuant to the order of the Honorable High Court, that proceedings was drawn. They have found the conclusion of the proceedings is at page number 29, and 28 is the order that was communicated to me. Yes. Now, subsequently, I challenged the entire proceedings. And filed the writ petition. That writ petition was filed in the year 2019. Now, subsequently, during the pendency of the writ petition, Lordship, the Karsiang, this road, Khaprel-Karsiang road, this was enhanced, this was widened, this was strengthened, this was maintained, but no encroachment was found on my land, Lordship. As a result, I was allowed to run my business from the place where I was running. Subsequently, in the year 2023, when the writ petition,
what is the order passed in the writ petition you have filed?
yes, in page number 34, I simply withdrawn the writ petition because my grievance has been addressed. I never had any grievance because during the pendency of the writ petition, whatever their allegation it was that I have encroaching on the PWD land or whatever, the PWD land was widened, it was maintained, but they did not found me to be an encroacher on the PWD land. As such, I had no grievance. I had withdrawn the writ petition. Can see page number 34. It is submitted on behalf of the writ petition that the grievance of the petitioner has been redressed. In view of the above, nothing further remains to be adjudicated in the writ petition, and the same is accordingly disposed of.
Where is that finding that you have not encroached?
Exactly.
Lordship,
Where is that finding of the authority that you have not encroached upon the road?
since I have not encroached, they did not take any steps pursuant to this letter dated 28, page 28. Had I been encroaching on the land, they would have removed my structure in terms of the letter which is at annexed page 28. This letter was issued to one Nizamuddin. I am Namiruddin. I don't know who this Nizamuddin is. I filed a writ petition stating that I am neither Nizamuddin nor I am connected to him. Honorable High Court directed to consider the representation of the private respondents without granting me an opportunity of hearing. Order was passed. So I filed this petition in the year 2019. In the meantime, Lordship, this road, Matigara Karshiang Highway, it was again widened, it was strengthened, it was maintained, it was again pitched. Lordship, they did not find my shop to be encroaching on either on the PWD land or on the PWD road. For 4 years, nothing happened, Lordship. Even after the encroachment, I was allowed to, even after the widening of the road, I was allowed to stay in the place where I was carrying business. So I withdrawn the petition because nothing survives. Now, all of a sudden, Lordship, and it comes to the next page, annexure P5, which is at page 35. In 2026, that was by the petition I had withdrawn in 2023.
Your petition number is?
My earlier petition number was 4386 of 2019.
4386.
It was withdrawn on 13 February 2023. Now, after elapse of 3 years, 2026, again they served me this notice. To whom? To Mr. Nizamuddin. I am not Nizamuddin. I don't know who this Nizamuddin is. Subject, notice for personal hearing and production of documents in connection with the alleged unauthorized occupation encroachment within the right of way of Matigara Karshiang Road in front of such and such. This notice was issued to me again on 2026, 17/4/26.
You have accepted the notice?
I did not accept the notice. The local police station called me and asked me to receive the notice. I have stated that in the body of the petition. I have stated it, that I was compelled to accept the notice.
Okay. You are Namiruddin.
I am Namiruddin. This notice is addressed to Nizamuddin.
Okay. Now this proceedings under section 10.
Under section 10 of the West Bengal Highways.
This is in respect of any complaint, press complaint lodged by anybody, or?
I'm coming to that. Page number 35. This notice dated is 17/4/2026. Kindly turns to page number 39. Further notice dated 20th April 2026. Again to Nizamuddin. I've been made to receive the notice to Nizamuddin. And along with this notice, a copy of the High Court order was attached. The High Court order is at page 41. This petition was filed by the private respondents. WP number 2363 of 2025, Binoy Agarwal versus State of West Bengal. Affidavit of services, I am reading the relevant portion. Affidavit of services taken on record. Despite service, none appears on behalf of the respondent number 6. Despite service, none appears. My case is that you are serving me this notice of proceedings. I was never a party. I was never given a notice of the writ petition. Subsequently, I obtained your lordship kindly takes page number 44.
Who is respondent number 6 in 2363? You are the respondent number 6.
Alleging me to be the respondent number 6. Alleging me. I am Namiruddin. And they have kindly see who is the respondent number 6. Page number 44. This is the I have obtained the relevant page of the writ petition 2363. This is the first page of the writ petition. Kindly turns the page. Page number 46. Respondent number 6. Nizamuddin, son of not known, residing post office, Matigara district, Darjeeling. With this address given in the cost title of a writ petition, service has been affected upon me. They give affidavit of service in the court. I don't know which postman has the accuracy to serve a notice on such notice, residing in post office. And who is this person? Nizamuddin. They are initiating postings against Nizamuddin. And in terms of this order passed in this petition, notices are being served upon me. When I refuse to receive the notice, local police stations called me, you are bound to take the notice. Subsequently, Lordship, I made a representation, page number 47. I have clarified my stance that I am nobody. I am not Nizamuddin. I am Narimuddin. I have no connection with him. Then, through the learned advocate on the court, this person has already also sent a demand representation, which is at page number 51.
That person has not sent it. It is by some Jahanara Neha, not by Nizamuddin or Narimuddin.
Then
Now, Lordship, when I am disputing before the authorities that I am not Nizamuddin, I was not made a party in the writ petition, no copy was served upon me. Absolutely, behind my back, order was passed in the Honorable High Court. I don't know how did the postman effect service in such a cryptic address, Lordship. In the meantime, an order was passed. I have used the supplementary affidavit.
Copy. Supplementary affidavit copy.
No, supplementary affidavit পরে আরো হয়েছে, ওটা তো তোমাদের আছে। Supplementary ছিল, তারপরে তো আবার ফাইনাল অর্ডার পাস করে দিয়েছে, কালকে পেয়েছি।
ওটা রিলাই করতে কপি দাও।
আমি সব লাস্টলি
yes.
প্রিন্সিপাল কপিটা আছে? ভাই আনসার নেই।
Next one, me.
That's all.
No, subsequently, Lordship, when I'm still disputing this addressee, subsequently, final order has been passed by the concerned authority in my name. When I have, in the meantime, I have filed the writ petition. This writ petition was filed before the vacation, summer vacations. When this writ petition I have served upon the concerned authority, they found that this person is Namiruddin. They corrected their stance. Instead of initiating the fresh proceedings afresh in the name of Namiruddin, giving actual address, they have passed the final order in my name, Namiruddin.
That possibly is not part of the record, my lord.
Yeah, I have received it yesterday, Lordship.
So let my learned friend come up by way of a supplementary affidavit if your lordship so desires.
Lordship.
We are in the dark about the document which my learned friend is relying upon.
Lordship, if may I, Lordship, I am for the private respondents, Lordship.
Then in that even supplementary affidavit
No,
will not,
kindly see, have a look at the final order.
Mr. Dhot, have it. Supplementary affidavit will not serve your purpose until and unless you challenge the final order.
Lordship, this final order has come to me yesterday, Lordship.
He
Now,
has challenged the writ petition at the stage of notice.
Yes.
Now he says
the
that has already
the
been.
writ petition was filed.
Please, hold on. I am with you.
Lordship.
The prayer in the writ petition at the stage of notice is being issued, that it has not been issued in your name, it has been issued in the name of respondent number 6, who is actually Nizamuddin, not Namiruddin.
Lordship.
Now we stand in a stage where the final order has been passed. There is no challenge to the final order. Now you have to file a fresh writ petition challenging for setting aside of that order on such ground. Otherwise, only bringing on a fact on record by way of a supplementary affidavit will not subserve your purpose. That is what I am on.
Yes.
So what you have to do is now you say that the final order has been passed, you withdraw the writ petition, I am granting you liberty, challenge that order on such ground that the proceedings is illegal since the notices which has been issued to you is in the name of Nijamuddin, not Namiruddin, which has been corrected subsequently at the time of final disposal of the application. Otherwise, you cannot challenge that in the present proceedings because the prayer is at the stage of notices. That is what I am on.
Yes, then Lordship kindly grants me the liberty to challenge this final order, Lordship.
Can you do that? Affidavit of
Lordship,
service
and in the
filed
meantime,
on
since
behalf
the
of the
may,
petitioner
may,
is taken on record. Mr. Debashish, sorry, Debashree Dhar, learned advocate for the petitioner, submits that during the pendency of the writ petition, final order has been passed in a proceedings under section 10 of the West Bengal Highways Act. He seeks to withdraw this writ petition with liberty to file a phrase challenging the final order. Accordingly, the writ petition is dismissed as withdrawn with liberty to file a phrase.
Lordship, kindly
applications.
include in the order that my dispute is with regard to the postings initiated in the name of a.
No, that cannot be done, my lord. That cannot be done. Because what my learned friend is now agitating is an order passed by an honorable coordinate bench, an observation. If my learned friend is aggrieved by that, he has to file an appeal or a leave to appeal. That cannot be agitated before your lordship.
But he
now.
can challenge the final order.
Yes, what my learned friend is now pointing out and has been pointing out is an observation made by the honorable coordinate bench in the other writ petition.
Since the basis of this order, the genesis itself is disputed.
That has not been challenged. That order at page 41 has not been challenged.
But I'm showing it before your lordship. This
Lordship is not sitting in appeal. Lordship is not sitting in appeal against that order. And they've chosen to not to appeal.
Lordship, all I am praying to kindly grants me a window of 7 days. Within 7 days, I will let them not take any steps in terms of.
That cannot be done. There is no writ petition pending, my lord.
When the order was passed, final order was passed.
Final order was passed on 2nd June 2026. It was served upon to my client yesterday, Lordship.
Fine. Next.
Lordship, then
Lordship.
What is the submission?
Lordship, may I say that? In the meantime, they kindly see the discrepancies. Initial notice, the proceedings under section 10 initiated on in the name of Nizamuddin. Final order is being passed in the name of Narimuddin. There is discrepancy on the face of it, Lordship. Kindly.
Then in that event, my lord, I'll direct your lordship to kindly hear it out, address it on facts, dismiss it with cost for suppression of fact. Because notices have been issued to Narimuddin, to the petitioner on 2 occasions. He has received it. On the earlier occasion, his wife has received it. Wife files an affidavit disclosing that she is the daughter of such and such, not disclosing that she is the wife of the petitioner. These are the complete suppression of fact. If my learned friend is pressing for a stay, I'll request your lordship to kindly take it up on merit, dismiss it, dismiss. Everything is there. Everything is there. But what has fallen from your lordship is apt. If I may show the discretion of saying this to the honorable court, that it is absolutely correct. The stage of issuance of notice has passed. In view of the submission made by my learned friend, that a final order has been passed. So today, if your lordship decides on the report, the final order stands, or it is there on record. So comprehensively, it has to be taken into record. And if this was served upon him yesterday, he could have prayed for a liberty, bring it on record by a supplementary affidavit. My learned friend chooses not to do that, brings a document from the bar. We are completely in the dark about it. So your lordship has correctly observed that a fresh cause of action has come.
He is aware of this final.
I am not. What document is showing, I don't know. It can be any document.
His department.
This
Then-
can
then-
be any
then-
document, my
then-
lord.
then, Lordship, may
I
say one
have to
thing?
then take instruction with
Then-
regard to that.
Then what? Then in the earlier order passed by the coordinator bench, Lordship, the coordinator bench directed to consider the representation.
The
Then-
earlier
then-
order, my lord, was very clear. The honorable court had given us the liberty to also look into any other encroachment, unauthorized encroachment. It is there. If your lordship, I'll take 1 minute of the valuable time of this honorable court, which is there at page 42. I'm placing it needless to mention, if any unauthorized construction is found, the same shall be removed strictly in accordance with law upon following the principles of natural justice and upon giving
Yes, this is with
adequate.
regard.
So
this
at
regard-
page 42, my
with
lord,
regard
at
to respondent
page
number
42.
6.
At page 42.
This is with regard to respondent number 6. The kindly see our representation. at
Kindly
page
see,
number
my lord,
47.
page 42. Any unauthorized construction.
Any unauthorized construction perpetrated to be made.
And
by the
even, my
respondent
lord,
number 6,
assuming, even, my lord,
not by
assuming,
any other third
even
party.
assuming for the sake of argument that there, this is only in respect with the respondent number 6, who the petitioner claims is not self. There is absolutely no stay either from this order or any order of the honorable court stopping us from taking any action in accordance with law in respect of any unauthorized construction.
Then Lordship kindly takes page 47 to reply to what has fallen from Lallet's near friend. Lordship kindly see page number 47. We have clarified the entire position.
Yes. 48, who has clarified, my lord?
Page 47.
Jahanara Neha, daughter of Aliyah Rahman. She deliberately suppressed that she is the wife of the petitioner and she has accepted a notice.
Acceptance of
Page
notice
48,
under threat
page
of the
48.
police. Jahanara.
Where is the complaint to the police authorities?
Jahanara Neha
Kindly
was
see
never a
page
party
48.
to the
Kindly see page
petition.
48. Jahanara Neha.
No, after the order was passed in 2363,
Lordship.
Yes.
in April 2026,
Lordship.
February 26.
Lordship.
Now, when was the notice served by the authority?
Notice was served by the authority, Lordship. First notice on 29/4/2026, after two months.
2 months.
28 April, my lord, a notice was issued to Muhammad
29/4,
Namiruddin.
Jahanara Neha, she was never a party to the writ proceedings.
28th April.
Kindly see page number 49, reference order dated 13/2/2026 passed by the Honorable High Court in WPN number 2363. She has been served with a copy of this order where she was never a party.
Lordship,
And who is the party to the merits to the writ? Is a complete unknown person. Kindly see the
See,
address.
as on date, as we stand, the final order has not been challenged. If you press for this prayer in the writ petition, we proceed in accordance with law. We find out and examine your contention.
I'll file a report,
What
my lord,
you are-
within 3 days.
Lordship, all I can say that আবার fresh postings করতে ওটা যদি আমাদের দোকানে নিয়ে থাকে
আমরা সোমবার
If my learned friend is pressing this writ petition, my lord will grant me an opportunity to file a report on affidavit within Monday.
এটা
I'll do that, my lord. I'm ready with that.
and we will file a supplementary.
বাস হয়ে গেল।
Affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks for setting aside and or cancellation of the notices dated 17th April 2026, 20th April 2026, and 29th April 2026 issued by the concerned authority. These notices are annexures. Please note.
দিকে আছে মনে হয়।
The notices are annexed from page number 40. The first notice is Lordship is annexed at page number 39, 37. Sorry, Lordship, 35. 35, 17 March 2026, addressed to Nizamuddin.
17th April.
17th April 2026.
Second notice is
20.
The second notice is 28th April 2026 to in favor of Jahanara Neha.
after my representation.
This notice has not been challenged. Notice to Jahanara has not been
Has
challenged.
not been challenged.
Then is 39.
No, since we have challenged the proceedings. These notices are all part of the same proceedings. We have challenged the proceedings itself.
The proceedings has not been challenged. The notices have been challenged.
Notices. Which
Where
proceeding
you
is my
have
learned
challenged the
friend?
proceedings? Where A, B, C, where you can.
According to my learned friend, the petitioner is
So,
not.
the actual notices 17/4, 24 and 29 April.
Notices.
All notices.
Mr. Kunaljit
I sent all
Bhattacharya,
notices.
learned advocate, learned additional government leader seeks to file a report.
By Monday, my lord. By tomorrow, I'll have it.
Seeks to file a report in the form of affidavit. Let such a report be filed on by the returnable date for 16th November. 16th কত আছে না? Monday on Monday?
Monday, as your lord.
I am also trying to file a supplementary affidavit.
With advance copy, my lord, because if an advance copy is not given, we will not be able to deal with that.
And Lordship also kindly direct them to file a report how at page number 46 how Nizamuddin this
That I cannot file. I am not the writ petitioner.
then
And my lord will
private
kindly not
correspondence-
do that for the simple reason, my lord. My lord is not sitting in appeal against that order. That writ petition was decided by an honorable coordinate bench. So if my learned friend for the petitioner is today aggrieved, he has his recourse before the honorable division bench.
Duram, learned advocate for the petitioner seeks liberty to file supplementary affidavit. Mr. Deboshidhar, learned advocate for the petitioner, submits that the final order has already been passed in a proceedings under section 10 of the West Bengal Highways Act. He seeks leave to file supplementary affidavit. Leave granted. Let such supplementary affidavit be filed by the returnable date. Advance copy be handed over to learned advocate for the state respondents, and sir is appearing for
A private response. Private 678.
678. Do that. 678.
My lord, Monday, my lord has been pleased to keep it on Monday.
Passover কি হলো দেখেন? Passover? Miss Agarwal? Where is Miss? 17. Wait, where is Mr. Mishra?
My lord, Mr. Mishra has already addressed your lordship.
No, I
Probably-
want to take your submission in his presence because he has placed two judgments of Madhya Pradesh High Court and of Allahabad High Court.
Yes, I will distinguish those because those are of no avail in these matters.
We'll see that.
Thus,
Where is Mr. Mishra?
may I send my
Give us
learned?
Mishra?
My lord,
My lords, he already has a fixed matter in the other court, court number 7. My lords, if kindly fix at 12:30. My lords, he's on his legs since 12:30, my lords.
Where is Mr. Ghosh?
Mr.
Ghosh was also there. Please intimate him at 12:30 I'll take it.
But my lord, those matters 1 and 2, I have only
I
one.
understand
very-
that your matter is separate from 1 and 2.
Yes,
But
and
we'll examine, he made
Actually,
a
Lord,
submission,
from
we'll
3 to
examine
9,
that. At 12:30, then you come, ask Mr. Mishra to come at 12.
because
Grateful,
all
my
the
lords.
matters have to be addressed separately, my lord. Grateful.
Grateful, my lords.
17, my lord. I am for the petitioner, my lord. I am led by Mr. Jana, my lord.
My lord, 17, I am
Jana
for
is-
the petitioner. My lord, the petitioner was an assistant teacher of a high school. My lord, she paid for, my lord, the conversion from CPF to GPF upon payment of a government share with 12% interest. Your lordships know, my lord, the similar order. My lord, the in principal bench has passed, my lord, one Dhirendranath Das. Your Lordship, I have, my junior will hand over the order of your Lordship, my Lord, the similar order can
এটা
be
অর্ডার আর এটা কারেক্টেড করে দিয়েছে, এটা কারেক্টেড করে দিয়ে আগে ওই অর্ডারটা দেন।
Lord, in view of the judgment of Abhijit Vaidya and subsequent judgment of the Muktimoi Pal, my Lord, the petitioner is entitled to receive pension subject to refund of the government share. Lord, the government share 12% interest, she has to refund the money.
This is husband.
No, no,
No, my Lord, petitioner herself, my Lord, he was an assistant teacher.
She opted for OPA 1990.
Yes, yes, she opted upon 1990 and retired, my Lord, at the age of 60 years.
So whether option was exercised under OPA 1990 or not?
Yes, yes. My Lord, she retired from on superannuation at the age of 60 years. So, my Lord, that is why, my Lord, she exercised option under OPA 1990. My Lord, I have stated, my Lord, paragraph 4, 5, 6. My Lord, she exercised option, and your Lordship also will find PPO was issued page 23.
Okay. Yes, sir.
Yes, I am representing state. The matter leaves the learned for discretion.
The subject to refund of the government share with 12% interest.
Affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks permission to deposit / refund the government share in contributory provident fund with interest and additional interest in order to avail the benefit of pension. The petitioner contends that she was an assistant teacher.
Retired from the headmistress.
She joined as an assistant teacher in joining in the same school.
Yes, yes, yes.
Joined as an assistant teacher in Sonada Holy Cross Girls Higher Secondary School, District Darjeeling, on 13th December 1993. The petitioner was promoted as headmistress in the said school promoted লিখলাম না লিখে দিন The petitioner retired from service on superannuation on 31st May 2022 as headmistress of the said school. The petitioner exercised option under Group of 1990 and 1998. In order to avail the benefit of pension, the petitioner intends to deposit / refund the government share in the contributory provident fund. Hence this writ petition. The submissions same. Mr. Shoktipodo Jana, learned advocate, appearing through virtual mode, relying on the decision para 4. Mr. Swensu, learned advocate, appearing for state respondents, leaves the matter to the discretion of the court. In line with the above decisions, again the sixth same.
Respondent number 3 instead of respondent number 4.
Respondent number 3, District Inspector of Schools, AC.
AC Darjeeling.
No, this is AC Darjeeling Hill areas. Respondent number 3 is directed to calculate the employer share of contributive provident fund with interest and additional interest from the date of superannuation which the petitioner is required to refund for availing the benefit of pension and intimate the same to the petitioner within a period of 8 weeks from date of communication of this order. The petitioner shall deposit the specified amount of employer share of CPF with interest and additional interest to the government treasury to the district inspector of schools. The concerned district inspector of schools shall send the pension papers of the petitioner to respondent number. Director is respondent number 4. Director of
number
pension.
4 and 5, my lord, now the deputy director
No.
Uttar Konna.
This one number 4. Deputy comes under it.
Number 4 and 5.
West Bengal, after verifying the same, and shall issue pension payment order in favor of the petitioner as expeditiously as possible. The pension shall be granted from the date following the date of retirement of the petitioner. Disposed of.
I get full to your lordship. পাচ্ছে না কেন?
12:30 time.
Mr. Jana is okay.
My lord, 19, my
Your
lord,
lordship, in item number 18, if before my learned
18,
senior
18.
initiates your lordship, I have already sent a scanned copy to the DI Shiliguri, your lordship. We are yet to get the instructions, your lordship.
Affidavit of service filed on behalf of the petitioner is taken
my
on
lord, the
record.
item number 18, my lord, the transfer application is pending at the school. My lord, now the DI has nothing to do. School has to, my lord, the school did not forward my transfer application. My lord, the
On Monday.
Monday.
On Monday.
After recording my submission, if your lordship is willing to pass an order directing the HY, your lordship, the state would abide by that, your lordship.
Yes, that
This
is
has
my
not
prayer.
reached.
My lord, directing the school to forward my application. Yesterday also, my lord, we delivered a judgment relying division bench judgment in Mithun Rai's case. My lord, because of the suspension, my lord, the petitioner applied offline.
No, this has been sent by the school or the school has not yet sent it.
Not yet sent.
School
The school has
yet
not
sent.
given its an NOC, your lordship.
Page 38 of my application.
When did you submit the application?
Page 38, 9th April 2026. Page 38 and my lord, the page 39 onwards prescribed format.
No, who is the administrator? This is administrator of the school.
Yes, now the school is running under the administrator. Previously also administrator is there. Administrator, my lord, the local sub-inspector of schools.
Okay. इसमें सुनीत रॉय আছে এতে দেখো তো সুনীত রায় দেখো তো অনলাইনে আছে কিনা মিস্টার রয় একটু পাসও করে কেউ বলো তো বলো Mr. Kundu, ask Mr. Sunit Kumar Roy to join.
Your
online.
lordship,
Mr. Jana,
the
Yes,
last
I
fast
page,
over for some time. Yes, yes. Ask
Yes,
Mr.
yes,
Roy
can you make it
join
possible?
online.
I will call my lord.
Yes.
Mr.
page
Sundra, I will request
42
you.
is incomplete, your lordship. That request to be done by the, yes, your lordship.
ওটা দিলেই তো হয়ে যায়।
Fast over?
Fast over.
Nick.
Great, lord.
Next, এভিডেন্স সার্ভিসটা দিলাম।
19. For that state, my lord.
The petition, and let him submit.
19 school had given no objection and forwarded to the DI. The school DI forwarding letter page 36. This is the transfer application. School has given NOC page 34, the prescribed format. Page 36 forwarding letter to the DI. DI has not yet taken any decision.
Yes, yes. 36. Now, where is your application?
No, my lord, page 43 is the forwarding letter.
No,
Before that
my
is the
application
43.
page 31. My transfer application
The
page
district
31.
inspector school, Siliguri. Forwarding is 43.
43, yes.
Forwarding is 43.
Yes, Mr. Bush.
Miller, kindly come to page number 3, Miller. Page number 5, Miller, paragraph number 3, Miller. The petitioner is the headmaster of a particular headmaster of a school, Miller. His residence is Siliguri, Miller. His wife is residing at Alipurduar. Miller, he is trying to transfer it from to Kolkata, Miller. And Miller, moreover, Miller, I have to take instruction over that, Miller. My instruction, Miller, they didn't receive the of that copy, Miller. So they that this require also time, Miller, so to give him intimation and verbally informing they have some difficulties over the staff of that school and the headmaster, Miller. That's why he's trying to flee from the school. So that's the verbal instruction, Miller. I'll make it Tuesday so that I can take proper instruction, Miller.
No, the
Affidavit of service filed on behalf of the petitioner is taken on record.
May I tell you, Lordship,
By
why
the present petition, the petitioner seeks direction upon the respondent authorities to particularly District Inspector of Schools AC Siliguri to forward the petitioner's transfer application dated 18th February 2026 to the West Bengal Central Service Commission for further consequential action. Mr. Where is the affidavit of service? Mr. Orijit Ghosh, learned advocate representing state respondent seeks accommodation to take instruction or file a report.
Yeah, I will take instruction, Miller. Tuesday.
Take proper instruction. After the 18th.
Yes, sir.
My lord, I am appearing in person. I have completed affidavit of service. May I submit my affidavit of service, my lord?
Yeah.
May I proceed, my lord? My matter relates to Special Intensive Revision 2026 regarding the deletion of my name from final electoral roll. Now the matter is pending before the appellate tribunal. I am praying for early trial in this appeal. By profession, I am an advocate, my lord. Your lordship, the reason of deletion is absolutely unjustified, unreasonable, and erroneous because of the following.
It's for the state.
Kindly see page number 45, my lord. This is the voter list of my parents of 2002. Of 2002. My father's name is in serial number 236, Mohir Ali Mia, son of.
What is your prayer?
Sir,
Prayer A, not maintainable before the court.
sir, my prayer is that kindly provide me early hearing.
So go back to the appellate authority tribunal where you have filed the appeal. Seek for an application, file an application seeking for expeditious dismissal. Why the writ court will get into all this? There is a tribunal set up by the order of the Honorable Supreme Court. If you are agreed, file an application for expeditious disposal of the case. And prayer A is not maintainable before this court.
Sir, please come to page number
Your
82.
prayer A is not maintainable before this court.
Sir, similar order has been passed in this court, sir. Please come to page number 82, sir. Sri Ikramul Haq versus the Union of India and others, sir.
What order has been filed? For restoration of your name?
No, sir, actually I am praying for early hearing, sir.
You are
Out of turn
requesting
hearing,
to
sir.
the appellate tribunal to dispose of it. That is much. No restoration. Prayer A is not maintainable.
Sir, I am seeking only the expeditious trial, sir. Before the tribunal, sir.
Is there an advocate in Jalpaiguri bench representing the election commission?
Sorry, sir.
Ask Mr. Bhattacharya.
I
Mr.
don't
Kunalji
have-
Bhattacharya.
Yes, sir. Your Lordship, I'm representing estate here. Yeah, we have no brief, Your Lordship.
You are
waiting for-
representing
Estate, Your Lordship.
state.
Yes, Your
State
Lordship.
means
So, Your Lordship, I don't have any brief, any kind of information.
no, the state is not a party here. All the election commission is a party.
Election Commissioner here.
So who represents election commission?
May I, Lordship, can I see the brief?
Yes.
I-
Who will represent election commission?
You give some time, your another date.
This is separate. This is we are not party. My lord, the election council commission has a separate panel of lawyers, my lord. State does not represent them.
So who is in Jalpaiguri bench, who appears?
Election commission,
Service has been evicted, my lord.
Somebody has to represent.
somebody else, my lord, not us, not even my learned friends sitting here, none of them. Somebody, as I've been informed by Mr. Ghosh, my lord, once Mr. Snehal Sinha appears from the principal bench.
Sonal Sinha.
Snehal, not Sonal. Snehal Sinha. Sorry. So I think, my lord, Mr. Haq would better serve them again once more or whatever. Give it back.
Okay. In this matter. Not required, no? What is not?
GTF is just
17.
Just find out whether. Come to page 84. Come to page 84 of your petition. What is the direction passed by Honorable Supreme Court in order dated 24th April 2026? Roman 3. Read Roman 3.
Roman 3. Roman 3. Yes, sir.
Read it.
As regards those petitioners, applicants, interveners, or other stakeholders, similarly placed persons who have approached the appellate tribunals, they may seek an out-of-turn hearing of their appeals based on urgency, if any, in terms of the order passed by this court, separately by order dated 13th April 2026.
What is the order passed in 13th April 2026?
My lord, I am facing serious problem. I have applied for
What is the direction given in 13th April order? Is it so that you file a writ petition? Or you have to approach the appellate tribunal seeking for your urgency? That is the only context.
Sir, I have urgency, sir. My lord, I have
So is
urgency.
it before the writ court or before the appellate tribunal?
Before the appellate tribunal, my lord.
Can you go before the appellate tribunal? Why you have filed a writ petition?
My lord, I am seeking just out of turn hearing, my lord.
You're not understanding.
I am just seeking direction, my lord.
If you have approached appellate tribunal, that you have done. So you approach for based on urgency of your appeal. If you intend to have it, you out of turn, you can file an application before the appellate tribunal.
Actually, sir, I have applied for a passport on 13th April 2026. My passport has been held due to
Affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks for direction, order / orders, direction or directions in the nature of mandamus directing the respondent authorities to restore the name of the petitioner to the electoral roll, and also praying for early hearing, expeditious hearing of the appeal, being number APS 2501 G 050 42653446 Petitioner contains that अच्छा ऊपर affidavit of service contains that he you are a lawyer.
Yes, my lord.
Contains that though his name, your list is, you're showing one list, that is page number.
My lord, page number 44, my lord. Page number 44, serial number 640, my lord. Ikramul Haq, son of Mohir Ali Mia.
Page 44. Serial number?
640.
640.
Yes, my lord.
This is of which year? This list of?
2026, my lord.
No, 45. 45 is 2002. Where is your name? Though his name.
My name is in 640, serial number 640, my lord.
Page 45.
Page 44, my lord.
Page 45. You have annexed one list of 2002.
Oh. Page 45, my lord.
Yes.
This is the
Where is
voter
your-
list. This is the voter list of my parents, my lord. My father's name is in serial number 236.
Okay.
Mohir Ali Mia, son of Monuddin Mia.
Your name is appearing in 44. Page 44, your name is appearing.
Yes, yes, my lord.
The voters list is not the voters list. Contains that. Contains that the petitioner duly submitted enumeration form on 6th November 2025 and attended the hearing. Before the booth level officer, in short BLO, on 22nd January 2026. Stop. However, in the final rules of SIR 2026, published on 28th February 2026, the petitioner's name was shown under adjudication in serial number 886, part 49, comma 4, Kujbihar.
My lord, kindly indulgence. Kindly come to page number 84, my lord, and paragraph number 7.
Yes.
Paragraph number 7, my lord. In view of the above,
Thank you. Dokhin Assembly constituency. Annexure A. Annexure A is at page number?
page number 84, my lord.
Annexure A.
Annexure
Annexure A
A,
page number.
Annexure A, my lord. Annexure A, page number 84.
Come to page 4 of your writ petition.
Yes, my lord.
C. C.
C.
This what you have stated is correct.
Be that as it may.
This data is correct. Enumeration form on 6th November 2025. You submitted that.
Yes, my lord.
On 22nd January 2026, the hearing was conducted by the BLO.
Yes, my lord.
On 28th February 2026, final rules of SI 2026 was published. It is correct.
Yes, my lord.
Now you show me this under adjudication serial number 886 part 49 for Kuch Bihar. You say this is letter A. Letter A is at page number?
Adjudication.
Letter A, annexure A.
My lord, kindly see page number 20.
12. 12. Page?
Page number 20, my lord. Page number 20, serial number 640, my lord. My name is there.
Yes. Ash. Mr. Akramul Haq, hence this writ petition seeking for appropriate relief. Mr. Akramul Haq, the petitioner in person, submits that he has filed an appeal against the order of the Election Commission putting him under adjudication before the appellate tribunal being appeal number, again number बोलना, first paragraph, such and such. He seeks for expeditious hearing. He seeks for a direction for expeditious hearing of the appeal. To buttress his contention, he relies on the decision of a coordinate bench of this court passed in WPA 643 of 2026, Sri Akramul Haq versus Union of India and others. despite service, none appears on behalf of the Election Commission of India. In line with the decision passed in Ikramul Haq, the writ petition is disposed of, requesting the SIR Appellate Tribunal to dispose of the SIR appeal filed by the petitioner as expeditiously as possible. Disposed of.
Much obliged, my lord.
Next.
21, Lordship, I'm for the petitioner, Lordship. Kindly fix the matter on 17th, Lordship. Conducting advocate is appearing virtually before your Lordship.
Lordship, I am appearing for the respondent.
This is for, what is the prayer?
Compassionate appointment, Lordship.
Compassionate appointment. This
Yes,
has
sir.
been rejected.
I don't know anything about that.
You don't know. This is the order has been challenged. This is rejected. Prayer for compassionate appointment rejected.
Lordship, actually, a conducting council is ill. So Lordship kindly fixed for Budhwar. Okay, Lordship 17.
Exception to power file correction. Exception to power file correction order name. Report possible. Education কেন? ও এখানে ফাইল করে। এর কি ডি ভট্টাচার্য সেপ্টেম্বর 2025 এ ফাইল করেছে। এক্সেপশনটা ওখানে কি করে নিয়ে নিল? The report record এলো না। যে রিপোর্ট রেকর্ডে এলো না অথচ এক্সেপশন ফাইল হলো ডিপার্টমেন্ট। On the joint prayer of learned advocates for the parties, release this matter on 17th.
Obliged.
22. Passover. It's a
Passover?
Your Lordship,
Lordship,
GTA matter already fixed on 17th.
Yes, sir, Lordship. There are some other matters also, Lordship, from item number 28 to 42.
28 to
42.
Appointment. All appointment.
Lordship, today I'm filing a affidavit in opposition, Lordship, on behalf of GTA.
which matter?
Lordship, GTA 28 to 42.
28 to 42, you are filing your affidavit in opposition.
Opposition Lordship on behalf of GTA Lordship.
ধরো ডাকা হোক আগে সিরিয়ালি জান না
At 2022, there are some connecting matters also. Let's say,
ঠিক আছে
আমি কি আইটেম নাম্বার গুলো লিখে দেবো এবিডিপির ইন অপোজিশন এর উপরে 22 তে অপোজিশন 28 to 42 তে অপোজিশন আছে
22, who is for the petitioner?
I'm for the petitioner.
22 is a application seeking transfer. 633.
I'm not aware of the facts, Your Lordship.
So why do you say that fix it on 17?
As I instructed that this is a GTA matter and there,
That is a separate matter. This is regularization of teaching and non-teaching staff. And this is of transfer.
kindly fix this matter also on 17th.
Why?
Transfer, regulation.
3. Who is respond number 3? West Bengal Board of Primary
Your
Education.
Lordship, brief is.
You are for West Bengal Board of Primary Education?
No, Lordship. All service matter are fixed on 17th, Your Lordship.
No, that is with regard to
Service
regularization of
matter,
teaching
Your
and
Lordship.
non-teaching. This is an application seeking for transfer.
Is it that? Brief কোথায় কারোর কাছে কারোর আমাদের brief নেই এগুলো কি মানে temporary to permanent এটা না it's a
No,
different
no, this is a simpliciter and application seeking transfer from one district to another. The board is the responding,
board is the
answering
respondent
respondent.
answering respondent
Your
GT
affidavit of service you are carrying, madam?
Well, I am for the board, but
You are for the
is GT also a party? Yes, in item 22.
GT is a party.
Transfer, transfer within the GTA region.
Yes, from Jalpaiguri to which place?
Jalpaiguri to?
I don't have the verb.
My lord,
I'm not
may I make
aware.
one humble submission, my lord? Since none of us are unfortunately prepared here, my lord, none of us. I'm not pointing finger to at Mr. Ghosh, I cannot do that. I have to stay in the bar. If your lordship, my lord, so commences can take it up either on 18th, my lord, because since these are different matters, not those matters, we will be prepared in those.
Madam,
My lord.
where is the affidavit of service?
My lord, I have served everything at the time of hearing when it was first came before this court, my lord. It's a long pending matter, my lord. It's relating to the regularization of appointment. Regularization of from temporary to permanent. Temporary to permanent. That is the same issue.
You are moving 633.
Item 22, my lord, is taking up.
22.
The 22 is bit. Yes, 633 of 2025. Naveen Pradhan versus the Gorkhaland Territorial Administration.
Oh, transfer বলছে
Transfer বলছো কেন?
এটা 633 of 2026. Your is 633 25.
2025, my lord.
ভুল রেকর্ড that 25 এর রেকর্ড লিস্ট হয়েছে 20.
My lord, what I am praying, my lord, 22 and 28 to 42, all are relating to regularization of appointment in GTA area, my lord. Then my lord will kindly take it up on 17. 17, my lord, that's I am praying, my lord.
22 and
22 and 28 to 42. 28 to 40? 42. 40 থেকে 42 নামগুলো দিয়ে দিও
17 হবেই না
ডেডিকেটেড ফাইল দিছি সাহেবের কাছে হ্যাঁ পহলা वाला আপডেট দিছি ওই জন্য বস হয়ে গেছে
পরে লিস্ট করো 42 অবধি দিতে করে 17
আরে ছাড়া হতে অনেক ফানি আর কি
in 28 to 42 you are for the petitioner in all the items.
Yes, my lord. 22 and 28 to 42.
17th অন্য কিছু থাকবে না কেন?
যা দিচ্ছ না, only fixed it on 17, my
How
lord.
many matters are there for regularization, Mr. Bhattacharya?
My lord,
How many are there?
every day, my lord, we get either new or pending matters, a lot of them, my lord. My lord, I have only 17. My
It
lord must have about 200 cases. No, 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 I have only 20 cases, my lord. Only 20 cases. And Mr. So, Bari has.
100 cases.
Mr. Bari is the
Has-
main.
Yes.
He possibly has truckload of cases. Train load. Train load.
On 17.
It's on my lord.
Obliged, my lord. Thank you.
22, 28 to 42.
Lordship 28 to 4. Lordship 28 to 42, I'm filing affidavit in office. On
In
behalf
all the
of
matters? All the matters? At order call. On behalf of
GT election.
28. 28 to the other? Jason Rai. Affidavit in opposition filed on behalf of respond number. Madam, respond number?
Respondent number.
Respondent number 2346, Lordship.
28.
42, 28 to 42. Respondent number
Only 28.
2346.
In 28, your respond number?
2346, Lordship.
2346 is taken on record. Oh, wait, our disposal.
আমরা তো সব সেম একদম কনফিডেন্টলি বলতে পারবো
হ্যাঁ, দেখছি।
MAT 106 of 2025 and MAT 110 of 2025, these have been disposed of. Can you say? The affidavit or not?
দিয়ে দেবটা।
28.
Jason Rai.
কি করে নেব, কোনো ডিরেকশন নেই।
বুধবার। না, দেবশিরা মঙ্গলবারে করবো। সোমবার মঙ্গলবারে করে নেবো। আসলোটা মেনশন করবো।
শুনছো? In this, there is no direction to file affidavit in opposition.
Other matters, my lord, they are by direction and they have filed in all the matters, my lord. 30 থেকে আছে।
An advocate for respondent GTA seeks to file affidavit in opposition. Let such affidavit in opposition be filed by the returnable date. On the next date, you file it. দেখি 28 থেকে 42 দেখি তো। 28 হয়ে গেল, 29, হ্যাঁ 29
Lordship. 29 same.
29.
নেবে তারা নেবে।
কল হলো কি?
ভাই থেকে
তো ব্যাক
দাও পরে হবে, এগুলো অ্যানালগাস ম্যাটার।
এখন
30 থেকে নিয়ে নেবে। 30-এ রঙ্কিত বিধাতা গুরু। 31 নিয়ে আসছিস? আগে একটু 31টা দেবেন।
30টা দেখো।
30.
পরে হবে।
Affidavit in opposition filed on behalf of 30. Item number 30, give your affidavit in opposition.
Lordship, item number 30, Lordship, affidavit in opposition is not prepared, Lordship.
In records where there is no direction, you have prepared your affidavit in opposition.
Lordship, next date, Lordship. 17.
The advocate for respondent GTA seeks extension of time to file affidavit in opposition. Let such affidavit in opposition be filed by the returnable date, is this matter on
31.
17.
Lordship, am I audible to your Lordship?
Ready?
31.
31টা দে।
353.
353 354.
Affidavit in opposition filed on behalf of the respondent GTA. Respondent numbers 2, 3, 4, 6. GTA is taken on record upon extension of copy you have given?
Yes, my lord.
Copy, sir. On the joint prayer of the parties, please this matter on 17th.
Thirty-two Charles Guru. 42.
Affidavit. Same one. Copy.
Soft copy received, my lord. আচ্ছা কি বলছেন তারপরে কোনটা
33
না পেছি না থ্যাংক ইউ ভালো থাকবেন থ্যাংক ইউ
Sir, you will be filing any reply?
No, my lord.
You have line affidavit copy, sir. Then the advocate for the petitioner submits that he will not be filing any petitioner submits that he will not be filing any reply to the affidavit in opposition. সবগুলো তো থাকবে যেখানে filing any reply to the affidavit in opposition.
Look at the 27 time লাগবে 34 PRI. PRI এর পরে তো জালিনা রাই
Same order. Next.
35
প্রীতিকা ছেত্রী জালিনা রাই এর পরে প্রীতিকা ছেত্রী
Gautam Babu, same order. 35.
शेख लीग ना दुआ बोलते हैं पार्टी ठीक जीटीए ठीक और माता पिता प्रतीका छत्री
36
प्रतीका छत्री तब नहीं जा रही
Same order. Check on same order. Copy has been given.
Yes, my lord.
Next.
तब मेरा राइट
37
मेरा राइट तब लवी शतवान
Same order.
ওই দিন থেকে জিটিয়ে হবে
আরো তিনটা নাম্বার ফিক্স করা 25 দিয়ে দিয়েছে
চাকরি লবি শতমান Peterson.
38. Same.
Peterson. Anita Devi Sharma.
Same.
Yes. 40. Anita Devi Sharma. What
22 days. Sir. I would together. Same.
Check. 41.
Same.
With the price. 42. কতটা 28 আর 29 বলিয়ে
23 থেকে টাকা হয়নি না? Same.
My lord, one indulgence, my lord. 28 and 29 are also same matter, my lord. If your lordships kindly take this affidavit in opposition, then those two matters can also be fixed on 17th, my lord.
I have granted him liberty to file that affidavit in opposition by the returnable date.
My lord, obliged.
On the returnable date, you file that.
My lord.
Because there was no such direction to file. So
My
right
lord.
now I passed a direction on next day they will file.
17 তারিখে জমা দিয়ে দিস। Obliged, my lord.
No, there is another matter. 22 is also there.
22, my lord, same matter, but that was regularization of appointment of a group C staff in GT area, my lord.
Group C. What is CAN? CAN to list আছে এখন? CAN 1 of 2025?
My lord, one person tried to interfere in this application, my lord, so they have filed an intervening application through CAN 1, my lord.
Okay.
22.
Who has filed CAN 1?
But no copy has been served upon me, my lord.
CAN 1. Okay, Isha Acharya is learned advocate.
Regularization, group C. This is relating to group C staff, my lord.
Group C.
Group C.
17th, the prayer of the learned advocates. This is the 17th. দেখো 12:30টার সময় তুমি মেনশনটা করে দাও পেপার কিনতে
Obliged, lordship.
Item number 18, my lord, Mr. Sunidra is here, my lord.
Item 2.
My lord, the item number 18, Mr. Sunidra, my lord.
Well, for 1 and 2, my lord, it should be less.
Only one.
Only one.
But I am, in terms of Millard, the last order that is recorded Millard, I am filing a supplementary affidavit. Now, Millard, the only issue here, Millard, as Mr. Mishra has already, Millard, made his submissions, that these are the matters where it would be appropriate to relegate it back to the tribunal. Now, Millard, here, the issue is not a purely dispute arising out of a demand of GST. The dispute is during 2017 and 18, when Millard, the GST regime came into place, from 1st of July 2017, several departments of the government of West Bengal had floated tenders without including the GST amount, because at that point of time, the applicable tax was VAT. So the tax rate of VAT and the GST rate, which subsequently came in, there was a difference. So that differential amount was not factored in by the government. In 2017, to mitigate this kind of situations, the government came up with a notification, which your lordship would find, Millard, at Millard, page 51 of the writ petition. Notification dated 16th of August 2017. Now, even this notification, Millard, failed to take into consideration the scenario where the departments have already floated NITs, but without factoring in the differential amount of GST. The grievance of this petitioner, Millard, is not only against the Department of GST. In any event, a demand is there, and order in original is staring at my face. There is no doubt about it. But the larger grievance is that if you make a demand from me, I am not supposed to pay this amount from my own coffers. It had to factor in by the governments, the departments, which had floated the tenders. Therefore, those departments are also, Millard, party respondents in the writ petition. And this is, Millard, an area where, Millard, till date, probably, Millard, there is not a lot of clarity, Millard. This requires to be addressed. So, Millard, this is not a case which should be, Millard, in other matters, Millard, where the appellate tribunal has, Millard, denied to entertain an appeal on the ground of condonation, tribunal. And order in original has been appealed against on merits, tribunal. There is no doubt about it. But this is a matter, Millard, which probably subject to correction, Millard, and subject to what Mr. Mishra says, Millard, travels a little beyond the scope and purview of the GST Act. So this, Millard, probably is one of the cases which should not be, Millard, purely relegated back to the appellate tribunal. That would be, Millard, a mere formality, an empty formality rather. Because GST appellate tribunal even will not have the power to adjudicate on this. Because as such, I am not questioning the demand raised. My grievance is not the demand. Had my cause of action was purely the demand, it would have been the appellate tribunal as well as the GST tribunal. But today my grievance is not the demand. My grievance is that yes, you have a demand, I agree. But the money has to come from somewhere else. Until unless that happens, Millard, I cannot fulfill this demand. This is, Millard, the crux of the writ petitions.
Lordship is right to some extent. There was initially every work that was done with the electricity or PWD or any other department, the GST rate was 12%. That was subsequently increased to 18%.
That 12%?
12% was subsequently increased to 18%. In some cases, the pre-GST period, post-GST period is there. Yes, this case is different. We will file the proper reply in this case. Or if you want the usual order that has been passed with the finance secretary.
No, Millard, that will not suffice.
No,
Millard,
that will suffice.
No, the finance secretary was not there.
No, Millard, Generally, in these kind of cases, the matter, there was a coordinate bench orders. I have those copy of those orders.
Yes, he's right, Milord, absolutely
It
right.
was referred to the
This
finance
court has
secretary because
referred
he
to
was
the
on top
finance
of
secretary.
things. So he will decide what needs to be done within 1 month, 2 months. In some cases, 1 month time was given. In some cases, 2 months time.
Milord, if I may I suggest this, subject to Mr. Mishra's consent, Milord, let them come up with a report. Milord, considering the present transitional situation, Milord, let them have adequate time for that. If the finance secretary has taken any decision, because to my knowledge, till yet no decision has come in.
No, in some of the cases, decision has been taken.
Milord,
In
let
some
the
of cases,
decision be filed
even
by
reimbursement
way
has
of a
been done.
report. Milord,
That is mine.
Milord, let a report be
In
filed
one of
along
my
with.
cases also reimbursement has been done.
Milord, let a copy of those decisions be filed by way of a report. The court can dispose it of accordingly.
Or even better, let it be kept on Monday. I will come up with the usual orders that the coordinate benches have passed. In this case, those orders may.
And Milord, if possible, the decision of the finance secretary, so that it can be disposed of, no difficulty.
Decision will not be there. That is on case to case basis. Generally, what order the reports have passed, we will come up with that on Monday.
Supplementary affidavit filed on behalf of the petitioner in terms of order dated 7th April 2025 is taken on record, copy served. Mr. Jagriti Misra, Learned Assistant Additional Advocate General, seeks accommodation. Release this matter.
Bring on record coordinate bench judgments on the same issue.
Seeks accommodation to place decisions of coordinate bench of this court on the returnable date. Release this matter on Monday.
Grateful, Milord. What are some more lucky लोग फोन करता रहता है?
Item 3. Yes. I'm appearing for the petitioner, my lord. My lord, what I have been given to understand that Mr. Mishra has, my dear friend, has taken a standpoint that all these matters has to be clubbed together and sent back to the remanded to the tribunal on certain arguments that he has advanced. Now, my lord, one of his pivotal arguments happens to be judgment. Madhya Pradesh High Court's judgment, which he has placed on record, where a few matters had been relegated to the tribunal. Now, my lord, in that same judgment, Lordship kindly comes to paragraph 26 and 27 of that judgment, Madhya Pradesh High Court's judgment. May I place paragraph 26?
Yes.
Ma'am. The Supreme Court, in the case of Whirlpool Corporation versus Registrar of Trademarks, reported in 1998, 8th volume SCC 1, in its landmark decision on the question of maintainability of the writ petition, despite availability of alternative remedy, held that under Article 226 of the Constitution, the High Court, having regard to the facts of the case, has discretion to entertain or not to entertain a writ petition. This much goes in favor of my friend. Thereafter, the High Court has imposed upon itself certain restrictions, one of which is that an effective and efficacious remedy is available. The High Court would not normally exercise its jurisdiction, but the alternative remedy has been consistently held by the Supreme Court not to operate as a bar in at least 4 contingencies, namely, where the writ petition has been filed for enforcement of any of the fundamental rights, or where there has been a violation of principle of natural justice, or where the order or proceedings are wholly without jurisdiction, or where the virus of the act is challenged. I continue to paragraph 27. The petitioner is not alleging violation of principles of natural justice. He was given opportunity to defend himself by filing a reply to the show cause notice. The petitioner is also not challenging the competency of the respondent's authority to issue show cause notice, as well as to decide the appeal. The petitioner is also not challenging constitutional validity of any statute. Therefore, in the circumstances, the remedy of writ petition cannot be permitted to be availed by passing the statutory remedy of appeal before the GST tribunal. Once the GSTAT has been established, the legal objection or grounds under the GST laws raised in the writ petition are liable to be appreciated by the learned tribunal. I pause here for a moment. So in this matter, admittedly, the question of natural justice did not arise. The question of patent illegality or the question of jurisdiction did not arise. Neither the question, the authority to issue such show cause notice ever arised. On that limited score, in tune with the ratio of the Whirlpool's case, this judgment was propounded. But in all these matters, right from 3 till 9, emphatic case has been made out, my lord, on the question of natural justice, on the question, in certain cases, in question of jurisdiction, and in certain cases, the competency of the authority concerned. I will show from each one of them, because, my lord, to my limited understanding, my lord, subject to correction from my lord, and whatever my learned friend has to submit on that. My lord, a writ proceeding is basically a proceeding where we challenge the niceties. We do not challenge the substantive remedy. It is the process that we challenge. I cannot nudge a writ court. I cannot go before a writ court seeking a substantive revaluation of an order unless there is a patent illegality. I cannot call on to the subjective satisfaction. A writ court is very different from an appeal court. So obviously, when I'm filing this writ petition, all these writ petitions, they challenge the process. They challenge the way the whole proceeding has been done. The illegality has to be established in the writ petition without any iota of doubt. A writ petition must establish the illegality. But just going by in gist, in serial number 3, Lordship needs not consult the briefs right now, just I'm narrating down. In serial number 3, a particular business woman has been tried by creating a parallel ID, although she is a registered dealer. Despite her being a registered dealer, an ID has been created behind her back. All notices have been sent there. It is like somebody creates an ID in my name, Bodhan Bhattacharya. I do not have any access to it. They serve me notices there. And one fine morning, they come to my place and say, see, this is your demand. It has been standing against you for the last 2 years. Gross violation of natural justice. Secondly, in this matter itself, Section 63 has been utilized. Section 63 is only for the unregistered dealers, unregistered persons, not for taxable persons. So the question of jurisdiction comes in. This is 3. 4. Section 74 has been resorted to. Should I pause, my lord?
Yes.
Mal.
If I can reply to 3, then we can move to 4.
No, I'm just listing it out first. My first argument relates to just that it should not be sent to the tribunal. Thereafter, I'll take up the merits.
Yes.
Yes. And thereafter, in 4, what happened? I had filed a return. That return was filed 28 days delayed. My input tax credit, my lord, what happens in GST laws? I'm sure my lord knows much better than me, but my lord, I'm just refreshing myself. What happens in GST laws? First, we file a return in GST at 3B. That return, we have to claim input tax credit because whatever I have purchased and the tax I have paid at the point of purchase, that gets deducted in my final output. So I have to claim by way of a return. I have to pay and I have to claim both by way of a return, GST at 3B. That has a particular cutoff date. And that cutoff date, after that cutoff date, if I prefer it, if I file it, under a provision, section 16(4), I'm not supposed to get that benefit. So I was late by 28 days. But the thing that they missed out, it was COVID period. Honorable Supreme Court had extended limitations for everything. So this is again a patent illegality looming large on the face of the order. For that, we do not need to go to the tribunal. A simple setting aside to the adjudicating authority in order to ascertain whether I have actually filed it within that period the Supreme Court allowed or not. That is the limited prayer in that matter. Thereafter, serial number 5. Here section 74 has been invoked. Now, my lord, section 73 and 74 under the GST Acts, these are the two adjudicatory sections. Likewise in assessment, as it happened in the earlier GST laws, assessment. Here in GST, 73 is the assessment where there is a short payment without any malicious intention, without any fraud, without any willful misstatement. 74 is resorted to whenever there is a fraud, there is a malicious intention, there is a willful suppression, then 74 comes. What is the difference, my lord? 73, the tax amount, the interest amount is same as 74 tax amount and interest amount. But in 73, the penalty is 10% or 25% or whatever. There are situations and stages. In 74, it is 100%. That's the only difference between 73 and 74. Now, my lord, there are notifications by the central and the state authorities, which show and which lays down profoundly that in order to resort to 74, you must make out a case of 74 in the show cause notice itself. It cannot be simply stated that I am satisfied that there is fraud. No. You have to make out the case of 74, a pre-show cause notice is to be given for that. That I suspect you have done these things which constitute as fraud. That was never done. Here, my lord, actually 74 was used for a different reason altogether. The limitation for section 73 was already over. They could not proceed against me in 73. So that is why they invoked 74. I will show in details. Now, my lord, what happened here? I have accepted my short payment. I made a mistake. I have accepted my short payment, paid my tax in full. Whatever the tax quantum is in 73, that is the tax quantum in 74. I paid my full tax quantum as per 73. And thereafter, I appealed in the first appeal, stating that, see, this is what has happened. They have not called out the provisions of section 74. They have not made out the case of section 74. So let us not get into that. I have paid the tax. Now kindly calculate the interest and I'll be happy to go. This is the third matter. Now, the other 4 matters here, my lord, the first appeal itself has not been filed. Why? Because adjudication order has been challenged on the ground of complete violation of natural justice. What has happened? The first one, what I say, the violation of natural justice, for example, in serial number 6, my show cause notice gives me the date for tendering a reply, on which day it was a calendar holiday by the state of West Bengal. On a calendar holiday, I went there. The office was closed. I have annexed the circular of the state of West Bengal, showing it as a calendar holiday in Durga Puja. In that very show cause notice, my personal hearing column is written as NA, not applicable. This is ground enough to set aside the adjudication order itself. Moreover, this was uploaded in a wrong tab. I could not see it from my portal. It is there were actually, when the first portal came up, there were 2 tabs. One is additional notice, the other one is notices. Now, there is no concept of additional notices in the GST laws. Neither the same is there in the rules or in the regulations. Only in the government issued FAQs, one can see what something called additional notice. They had made a sweet distinction that these matters should go into the additional notice, these matters should go into the general notices tab. They were placed in different columns. So when somebody mistakenly uploaded the notices in the additional notices tab, there had been plethora of cases. And it was my great opportunity to come up with such a case for the very first occasion. And there's a detailed order of this honorable court that if it is uploaded in the additional notices tab, it has to go. The order has to go. And that has been the straightforward holdings of the judiciary from the very inception. And that Ishan Snacks's order, that was cited everywhere. Now, my lord, what happened? After seeing this, the government had made an overhaul in their portal. What did they do? Additional notice tab was brought just side by side to the notice tab. Although you have to select it in order to see. If I do not select, I will not be able to see. The adjudication notices are supposed to be given in the notices tab, not under the additional notices tab. So obviously I have not checked. When this matter came up before the Honorable Court and they took the plea of overhaul, again in another matter, I had the opportunity where I convinced the Honorable Court, and the Honorable Court was of the opinion that no, putting it side by side also does not cure that defect. So again the order was passed that no, these orders should go. That had been the law. Thereafter, on 5th February 2026, they did away with the additional notices tab. They merged it in one place. So now the defect has been cleared. But prior to that, most of the notices, in many cases, most of the notices were sent in the additional notice tab. Now, what happened, my lord? They will upload the notice in the additional notice tab. I would not know. Pre-show cause, unattended. Show cause, unattended. Final order of adjudication, unattended. They will sit tight for 3 months because there is a legal provision. I do not come to know. After the completion of 3 months or 4 months or 6 months or 1 year, they will issue me a notice which will show as a liability. Liabilities are not uploaded in the notices tab. They are either given by email or they are flashed in the different column of the portal. From the portal also I can see, from the mail also I can see. Now, all on a sudden, after 2.5 years, 3 years, I get to see there is a liability. And I do not know where from it has come. I get into the portal and then I see that, oh my God, this has happened 2.5 years or 3 years ago. Everything ex parte. Because this reflects a very sad credence on the assessee's conduct. Everything ex parte. But this has got a reason. And due to this reason, my lord, these went unnoticed. And all these matters, delay of somewhere 40 days, somewhere 50 days, somewhere 7 months, 3 months delay. And on the question of delay, the appeal has been, but here, my lord, I am not on the appellate order where the appeal has been filed. I am not on the appellate order. I am on the question that the adjudication order itself is devoid of natural justice, or in excess of jurisdiction, or wrongful assumption of jurisdiction. And where no appeal has been filed, there, my lord, my humble submission is only this. There the adjudication order is under challenge. And GSTAT is the second appellate authority. But for example, under CPC, if I do not prefer a first appeal, can I be relegated to the second appeal? I ask this question to myself. Similarly, here as well, I have not preferred the first appeal. GSTAT is the second appeal. I cannot be relegated back to GSTAT, especially where my first appeals are not there. And where my first appeals are there the challenge is not against the appellate order only, not the appellate order simpliciter, but the adjudication order which gives rise to that appellate order. I am more aggrieved by the adjudication order than the appellate order. Because I have already lost 2 fora. Adjudication I lost, ex parte. Appeal also I lost. So I have already suffered in 2 fora, my lord. And lordship will kindly appreciate, I have given a 10% deposit. In many cases, despite paying the tax, I have given a 10% deposit in the appellate stage. And in the appellate stage, they have taken that 10% deposit. And now if we are relegated to the GSTAT, we are again forced to pay a 10% deposit. And whenever these money comes back after 3, 4, 5, 7, 10 years, they are not given out with interest. Even if I win, interest is never awarded to the assessee. Although we pay interest for day. So, my lord, this is my preliminary submission on since Lordship wanted to hear all the 9 in a club fashion, this is my preliminary submission on all the 9s, that none of them be relegated to the tribunal because of these reasons which I have told. Now, if your Lordship wants me to continue, or my learned friend can answer to this, or I can continue from serial number 3 itself, each one by one, whatever Lordship pleases.
If I can have my Lordship for a moment on the GST Act.
Oh, just a moment. You have actually given me that. I'm sorry. Lordship will kindly take section 112 once. Thank you.
With the GST.
$112 is the provision for the appeal. 112(1), subsection 1. May I place, my lord?
Yes.
Grateful. Any person aggrieved by an order passed against him under section 107, that is the appeal, or section 108, that's rectification of this act, or the state of, it's not rectification, it should be better termed as revision. I can prefer a revision, or I can go before the appeal. So it is another second proceeding, not an adjudication. Adjudication is only under 73, 74 or 74A. So any person aggrieved by an order passed against him under section 107 or 108 of this act, or the SGST or the UTGST, may appeal to the appellate tribunal against such order within 3 months from the date on which the order sought to be appealed against is communicated to the person preferring the appeal. So, my lord, if I have not preferred a first appeal, that is section 107. If I have not preferred a section 100, there is no section 108 proceeding against me, then section 112 does not apply. If today I am relegated back to the GSTAT without me preferring a first appeal, that order, my lord, I'm afraid that is not what the law warrants. I should be very candid before your lordship. A few ex parte orders from this coordinate bench, from this High Court, another coordinate bench has passed where first appeal was not preferred, relegated to the GSTAT. But in my humble submission, my lord, that does not reflect the true position of the law, since it has already been challenged before the Honorable Division Bench. And it was an ex parte order. There was no one in front of the bench to apprise the Honorable Bench of this situation. I'm confident that the bench did not know what the provision of law is actually on this issue, because there was no such discussion on that point. No.
But suppose 107 appeal or 108 appeal is not filed. After a considerable period, a writ petition is filed.
Yes.
Now it is up to the petitioner
to
file an
establish.
appeal, because this is a statutory right given to the petitioner.
Absolutely.
That is not exercised by the petitioner.
No, my lord, I will tell you, lordship. Yeah.
Coming before writ court, as if you go back under 107, you have to seek for condemnation of delay, whether any provision is there or not. Without seeking for that and not availing the statutory appeal, you say that since it has not been appealed, so writ jurisdiction will be invoked.
Yes. Now I will tell you, lordship. The problem with the condonation of delay is another problem, which is a burning topic right now. First, it is the consistent view of the revenue that they can only condone 1 month's delay, not more than that. Not more than that. That has been their consistent stance. Every day, 10s and 20s in scores, matters are dismissed on the ground that we do not have power to condone. Lordship kindly takes 107, section 107.
3 months is the time.
3 months is the time, and 107(4). Lordship kindly takes 107(4). The appellate authority may, if he is satisfied that the appellant was prevented by sufficient cause from presenting the appeal within the aforesaid period of 3 months or 6 months is for government, as the case may be, allow it to be presented within a period of 1 month, further period of 1 month. Here is where, my lord, hands are getting tied. Because what happens, my lord, if an order is uploaded in the wrong tab, I discover it after 2.5 years, and that too upon their reminder notice. My hands are tied. I cannot go before the appellate authority. And moreover, my right to participate in adjudication also goes out of the window, my lord. Because none of the notices were given to me. It was uploaded in a wrong tab. I was not supposed to see, I was not supposed to know, and I did not know.
Is
So it is like
the provisions. Suppose a second appeal is preferred before the tribunal, and thereafter one loses. What is the remedy now after
before
that?
the High Court.
Then again you come to the High Court.
No, but not by way of a writ petition. Lordship will kindly appreciate one thing. The biggest problem is in these two steps, we are losing out 10%, 10%, 20% of the disputed money. Number one. Number two, the question is this: should the government be allowed to take advantage of its own wrong? I ask this question to myself: whose fault is it that the notices were not given properly? The notices were uploaded in a wrong tab. Whose fault is it that just
But
because
suppose you exercise your statutory right under 107, 108, there is a delay.
107, my lord, let us concentrate
107.
on 107 because
There is a
108 is a very
Now the only option open to the first appellate authority is to reject the application on ground of delay.
right.
Now you have a ground to file a second appeal,
Yes.
challenging that.
Yes. My lord, the question is, I am not on the appellate order at all. I am on the adjudication. If the genesis is wrong itself, that's the question of natural justice. That's the question which was reiterated in Whirlpool.
No, again, a question comes up.
Well-
That is, suppose in a civil proceedings, an ex parte order is passed. Palpably from the record is found that the defendants were not served. This is a violation of natural justice since opportunity was not given. But he cannot file his remedy before the writ court. He has to go under Order 9, Rule 13 or file an appeal under 96 seeking for setting aside of the ex parte order. Now, you said violation of principle of natural justice, violation of principle of justice, natural justice, where you have no other remedy left.
No, my lord. It is the question of
It's-
alternative remedy being
This, when an act has been framed, giving a right of appeal and also a tribunal being in place. So without exercising your right, you have exercised your right by way of a writ petition. That is where it is. Because if you are agreed by the adjudicating order, then 107 is there. You have failed because that tab was not functional, but you cannot access that, and you did not get any information. After 2.5 years, you get the information. Fine. The same ground is taken in first appeal. The first appeal court says that you are delayed. Now it goes to second appeal. You have another option after second appeal to come before the High Court for adjudication that this has happened.
now again, my lord, subject to correction from lodge. My lord, this was exactly the question that arose in the Whirlpool Corporation versus Registrar of Trademarks. What happened there, my lord? It came from a civil background only. It was the action in the trademark laws, not it came up from the district court. The same question arose that they have no jurisdiction, that the question regarding natural justice, whether it can be taken up or not. There is where the Supreme Court came in, and it was, my lord, may I place কিভাবে দেবো এত বড় judgment? My lord, I will
দেখো চেম্বার থেকে ল্যাপটপটা নিয়ে এসো।
না না তুমি এটা বার করো 1998 8 ভলিউম এসসি 1
চেয়ারে আছে।
That is where it was stated that in case of jurisdictional usurpation, in case of patent illegality, in case of violation of natural justice, writ petition can be accepted. Now, obviously, it is a discretionary power. Discretion can be accepted And it is me who has to impress upon the court that this demands an interference. That can be proved by me only when I open the brief. For example, in the first case,
Whirlpool, or in case of Harbanslal Khurana, or in HPCL, or in another case,
Motilal Padampat Sugar Mills.
the tribunal was not there.
True, it is not the question of tribunal.
Tribunal is governed by L. Chandra Kumar.
L. Chandra Kumar talks about the constitutional tribunal under 323A and B.
323B, this is also a tribunal, my lords.
But this is not a 323A or B tribunal. This is a statutory tribunal.
This is a complete.
For example, CAT, SAT, LAT, WDTT. These are tribunals under 323A and B. That is why L. Chandrakumar happened in the first place. My beloved friend, I know he also knows, I'm confident he will be at one page with me. Why L. Chandrakumar happened? Because Sampath Kumar happened. What did Sampath Kumar do? Sampath Kumar's judgment said that although the high courts are there, in specific matters, the matters in specified statutes from the tribunal will go to the Supreme Court directly. Supreme Court became flooded. So Sampath Kumar was reviewed in L. Chandrakumar 1996. There Supreme Court said no. From there the concept of division bench came, L. Chandrakumar. There the Supreme Court said no. Although there are specialized tribunals, the single bench, that's the writ court, will have no jurisdiction. But High Court being the topmost fountainhead of the judiciary in a state, there will be a power of revision. Revisionary jurisdiction is given to the High Court, to the division bench of the High Court. That has got nothing to do with today's matter at hand. Because Chandra Kumar said that division bench will have the supervisionary power over the tribunal. Even today that is the same case. And this is for statutory tribunals, my lord. Not for, this is not for statutory tribunals. This is for 323A and 323B tribunals, constitutional tribunals. What are the constitutional tribunals? The land tribunal, the service tribunal of the state, that is administrative tribunal, the central administrative tribunal, and the West Bengal taxation tribunal. In our state, these are the 4 tribunals that are there in under the 323B, and A is CAT. A is for central, B is for state. Now, in that case, L. Chandra Kumar comes in. L. Chandra Kumar has no application out here, I'm afraid, because L. Chandra Kumar says division bench will be the guardian of the tribunals. Division bench will be the supervisory body. It never says that the writ court will have no jurisdiction. No, writ court will have no jurisdiction flows from Sampath Kumar. And Sampath Kumar says writ court will not have jurisdiction, directly Supreme Court will take it. And even Lordship knows much better than me. For example, in Calcutta High Court, when we go against an order of the Honorable West Bengal Appellate Administrative Tribunal, it is WPST, Writ Petition Service SAT. Against the Taxation Tribunal, it is WPTT, Writ Petition Taxation Tribunal. LRT, WBLRT, WPLRT. These are all in the nature of writ petitions. Read with Article 227. It is not the case that here we are propounding something new. This has always been the point of law. This has always remained the point of law and hopefully will remain the point of law. Yes, it is not as a matter of right that I can say that writ jurisdiction I am amenable to, but it is a matter of discretion, and the discretion can be only utilized, only used when I actually show before your lordship the degree of my suffering, the degree of illegality. If there I fail, my lord, then obviously I will be out of the court. But I have not yet started. The degree of injustice meted and doled against me, if I show that, then only lordship can use your lordship's discretion to decide whether or not to entertain me. But I have not yet opened the brief at all. In the very outset, at the very outset, when Millard, the question arises that as a matter of practice, it should be sent to the tribunal. There is where I join my issue. But no, at least in these cases, and my learned friend has also shown the judgment of the Madhya Pradesh High Court. There also that paragraph is there, that in these four cases, this is the exception. And another additional paragraph, paragraph 27, as I pointed it out, in those cases, none of them were present.
It was in CGST tribunals, when it is beyond the 3 months as well as the extended 1 month, is an application under section 5 for condonation of delay can be filed seeking on the ground that these are the aspects.
If I can have my lordship for a moment on 107 once again. What we need to understand, my lords, is that this is a complete code in itself. It is a special law. It is a complete code in itself. Every act that happens under this law, the remedy thereof is provided under the law itself. The act itself provides for that remedy. The opening line in 107 says, any person agrees by any decision or order passed. Today, for example, he has a real life situation. He has exemplified before my lordship, additional tab or whatever. He couldn't have a look at it for 2.5 years. He can still prefer an appeal under 107. It will get rejected on the ground of limitation. Then thereafter he can go to the tribunal.
Yes.
When the question of bypassing the tribunal comes,
Then
High Court doors were open only because the tribunal was not functional and a person couldn't be left remediless. I am on the principles of convenience and discretion.
And for this,
And then, I will finish. Just a moment.
Please,
And
please,
then,
please, I'm
if I
sorry.
have my lordship, for a moment, my lords, on 112. No, 120. No, 120. 112. Sorry, my lord, 170.
Acha. Oh, High
What
Court.
will happen thereafter? Any person aggrieved by an order passed by the state benches of the appellate tribunal may file an appeal before the High Court, and the High Court may admit such appeal. Then it will amount to a WPGST.
Yes.
So right now, this bypass mechanism was happening simply because the tribunal was not functional. Today, the tribunal is functional. There are 5 courts, 5 judicial members, 5 technical members. Cause list is out. People, they are already approaching with similar grievances. They are already approaching the tribunal. What stops somebody? And what is it that you can say before a red court that you cannot say before a tribunal?
Sorry.
Now, my lord, 3 points my learned friend has called out very efficiently. First one, does that mean that today the government will resort to irregularity bordering on the ledge of illegality? And I pay
All errors will be corrected only by the High Court and not by the tribunal. From where that presumption is coming.
So it's like the government, will it be allowed to take advantage of its own fault? Because we have to understand one thing, 10% plus 10%, 20%. If it is a demand of say 4.5 crore, 20% is not a small amount. That 20% the government is appropriating at my cost. When I win, giving it back as a simpliciter money without any interest. Should they be given? Should they be given this leverage at my cost? This is the first question that calls for answer. Secondly, an injustice, or rather a violation of natural justice done in the hearing of tier 1, can it be cleared in the hearing of tier 2? I ask this question to myself. There are thousands of judgments of the Honorable Supreme Court which says, if in the first stage natural justice is violated, giving hearing in the second stage is no defense. Here we are talking about giving hearing in the third stage, more so. I will produce all the judgments. I'm armed with all the judgments. I'll produce each and every one of them, whatever I'm telling you. So the question first is, today, I have not been served. I have not been given a copy. I have been asked to visit the office for the purpose of hearing on a date which is a calendar holiday for the state of West Bengal. I go there, I come back, order is passed, ex parte order, none appears, fails to produce, does not produce a single scrap of document. These are the orders. And thereafter, I will go before the appellate authority because he will give me a hearing or a semblance of it. What about my right in the adjudication order?
No, your submission is proceeding as a, you are preempting something.
No, this is my case. This is my case. My serial number 3, this is the exact case.
Since there is a violation of principle natural justice in tier 1.
I'm not assuming. This is my case in my
I'm not on that. I'm not on
Within the
that.
limitation period, the
We are-
tier 2 will correct it.
The only point which is going on my mind is, you say that you are not informed. Fine, you have no information that such and such order is passed.
True.
In tab, you cannot access.
True.
Correct?
True.
After 1 year or 1.5 years, you come to know that there is an order passed.
True.
At that point of time, 107 you cannot avail because 3 months have already gone and extended 1 month gone.
Very true.
My question is, can you overreach by not filing a statutory appeal before
No,
the
no, I'm
authority
not.
on this contention, on the ground that you did not have the faintest of knowledge of what has gone down back behind you?
No, my lord, that is not my submission. My submission is this, that in the first level, not only the order was uploaded in the wrong tab, the notice calling me upon for hearing was also on the wrong tab. So I missed the opportunity of getting heard in the first year at all, completely zero. It cannot be corrected in appeal, my humble submission.
Taking cue from your submission, you say that the matter cannot be relegated to the second appellate authority, which is the tribunal, without availing a first appeal.
True.
Correct?
It cannot also be given to the first appellate authority.
Now, suppose
My lord.
you are sent to the first appeal under 107.
No, my lord, I'm not
No,
on that.
Suppose.
My prayer is to go before the
Can
adjudicating
that
authority.
be done? If that be done, then one has to record that since these facts have gone, so the appellate tribunal need not go into the point of limitation and accept your appeal under 107. So you start from that stage. Can it be done? If a person,
If your
for
lordship
any
passes
reason,
such an order,
for-
I will abide by.
Just a minute, I put it.
Yes.
For any reason whatsoever, a person does not or could not, rather, as you have submitted, could not apply for a first appeal under 107.
True.
There is a right existing in the act itself. So you prefer it, knowing fully well that since it is delayed, it has to be rejected. Now the person has an option to go for the second appeal and come back to the High Court under 117. This is provision.
No, the option is there, but my question is, when I'm challenging the first adjudication order, not the appeal, I'm challenging the adjudication order being completely devoid of giving me any opportunity of being heard. Can it be cured in the second appeal? For example, my lord, in the first, not example, let us take the case which is appearing at serial number 8. My lord, here in this matter, I have come against an adjudication order. Why? Because the adjudication order did not give me any date for hearing. It had not given me any date for preferring my reply to the show cause notice. The date that was given was a day in the Puja vacation marked as a holiday of the West Bengal government's calendar. And the office was under lock and key on that very day. I have annexed the notification as well. So, can it lie in the mouths of the revenue to plead that this gentleman has not got any opportunity of being heard in the adjudication stage? What is there? What is the problem with that? He can go to the first appeal. It is like Antonio Netmalon. If they don't have bread, why don't they have cakes? My first adjudicatory tier, where I'm to get an opportunity of appearance and putting my case across. 73, subsection 5, 74, subsection 3. That is taken up. Hold away. And now I am being advised to go before the appellate authority, pay 10% more. Appellate authority will hear. Why? I asked this question to myself. Why? Because my first adjudication, which you were supposed and liable to give me an opportunity of being heard, you have never given me. Now, how can you say go before, suffer some more? Why? Why this attitude, suffer some more? This attitude is suffer some more. Why? Is it a crime that I do a business? I contribute to the economy? Of course, that's not. This is my humble submission. This is where precisely where the shoe pinches. Today, had it been an adjudication order which is represented on merit, I wouldn't have said anything of this. Yes, your lordships are whatever was fallen from your lordships would have been absolutely true. But it is not that. An ex parte order, not considering my documents. I have declared my turnover to be 5 rupees. They have made it 25 lakhs without any rhyme or reason. And that too for the fault of their own.
GST motion is released.
I'm grateful.
We'll take it one by one.
I'm grateful.
Facts are different.
I'm grateful. Lordship, may I humbly
Mr.
submit one thing? Only one very small
Before
submission.
you begin, because I know from the registry, I have been informed that there are several GST matters.
Yes.
So which you think that it should go to the tribunal, we make a formal order and send it giving liberty to.
No, I will. No. You might have.
The matters which you say that the invocation of Article 226 can be made.
Yes.
That we can hear it out and examine whether this can be made.
One
So
matter,
far
one
as the
matter out of
So
this.
far as the matters which can straightway go to the GST tribunal.
Yes.
You can provide the
I
numbers
will.
which can be listed, and by a formal order, this can be
Yes.
giving liberty to file appeal.
Yes.
Because
Out of
he has produced a notification which has been
yes, I have
indicated
seen.
in
I'm
the
privy to that.
30th June is the last date. So if it can be
A
liberty,
bit
can
of
be given,
extension can be given. I will go in those matters.
so you give the numbers, we find it out.
Yes.
And so far as these are concerned, we list it under GST motion, we take it one by one.
Yes. Only humble prayer, my lord, if the matter can be taken up on Wednesday or afterwards, because my mother is undergoing a surgery. I had to postpone it to come to Jalpaiguri for this.
Then it goes to the next circuit.
Let it go to the next, but at least 2-3 matters can be taken up, my lord. Wednesday, because this is my earnest prayer, because
Wednesday, that GAT
My
matter is.
request not still remains, whatever he has said, it can be easily said before the tribunal. That what order will the High Court pass? He will send it back to the adjudicating authority. The same order will be passed by the tribunal
no, but
also.
that's the problem. That there is where the
That's
foot
all.
pinches.
GST fix for the Thursday, the fix for the king.
I'm grateful to my lord.
It's a 3-2,
My lord, 3 to 9.
3-9, all cannot be taken up.
3 can be taken up, 8 can be taken up, my lord. This won't take much time. And 3, 4, and 8 can be taken up. This won't take much time.
3-9 Raku, GST motion. Mr. Misra, will you be filing any opposition to the writ petition so that the
Markar
pleadings
nahi.
can-
In all probability, I think this petition has to go to the tribunal. I have other judgments. I will bring it on the next letter. Which clearly says, and in which cases, my lord, it
On
has to
the-
be retained, in which cases it hasn't to be retained.
Prayer of learned advocate for the petitioner.
Lordship 6 to 9,
Please
I'm
the
preparing for union of
matter
India.
on 17, Mr. Misra, regarding GTA matter, how long it will
GTAs
take?
are all, there, my lords, let it be placed on the second half then.
Second.
I do not know when,
Yes,
whether my
yes,
lords will be taking GTA in the first half or the second
First
half.
half, first.
First half GTA, second half GST.
On 17th then, we are placing all the matters, let's see how much I,
17th is Wednesday, my lord. Any day after Wednesday.
and then 18th.
Acha, 2 o'clock. 18th. 18th will be
17 2 o'clock. My permission to
18th.
18th. Grateful.
My
I'm
lord,
grateful.
my lord, in item
grateful.
number 345, my
But
lord,
that
number
point is
345,
still
I am
going
for
on.
the CJST.
Yes, I
Regarding
understand, my lord.
overreaching
I
of
will also
section
try and
My lordship is
Uh,
I
referring
will
for 1 to 9.
convince my lords this matter then it will go to the tribunal.
we will both try to convince my lord, and my lord will be convinced on your lordship's own account.
My lordship is
Thank you,
number
sir.
1 to 9.
Grateful, my lord.
We are
3 to 9 crore.
It was a matter of deep honor to appear, lord.
Thank
For
you.
your lordship. Grateful.
Lordship, we are appearing for in this matter, Union of India, Lordship.
In 3 to 5, I am appearing for CGST department, my lord.
Item number 10.
I'm for the petitioner, my lord. This is the affidavit of service.
Ashun, state. Ashun, evidence will be filed on behalf of the petition is taken on record. By the present writ petition, the petitioner seeks for direction upon the respondent authorities to disburse interest on delayed payment of arrear pension from the date following the date of retirement till the date of actual payment at the rate of 10% per annum. Petitioner contains that she was an approved teacher of Para 2, sorry. MC William R.R. Primary, Bananda. The petitioner retired from service on superannuation on 31st January 2020. The pension payment order was issued on 17th August 2022.
My lord, 4th August 2022.
4th August 2022. The arrears were received on which date?
17th August 2022.
The arrear pension was petitioner received the arrear pension but disbursed in favor of the petitioner on 17th August 2022. However, no interest was paid, hence this writ petition. Baki submission same, delay clause to thakbe. 6 weeks. 8% from the date following the date of retirement till the date of actual payment. Dispose of.
Wait, my lord.
Eighteen.
Item 18.
Item 18, I'm appearing on behalf of the state
Petition.
led by Ms. Radhika Agarwal, Your Lordship.
তাহলে কি গো পিটিশন তো নেই দেবজিৎ কুন্ডু ছিল
In item number 18, Mr. Shaktipato Jana appearing on virtual mode.
Mr. Sunit Roy is appearing.
Shaktipato Jana. Petitioner, for petitioner.
He was informed and he was appearing in the first half, Your Lordship. But presently, I don't think he is there.
কিন্তু থাক পাস সুনীত রয় ওটা এলে বলে দিন সুনীত রয় থাক
23. That's it. I'm hearing for the income tax authority.
For the petitioner's
case, against the interim order, the petitioners referred the intercourt appeal, Your Lordships. And in the appellate court, that is dispose of the appeal along with the writ petition, Your Lordships, both. The order is Your Lordship.
It has to be disposed of. Which paragraph?
Last.
Learned advocate for the petitioner submits that in appeal being MAT 56 of 2025, submits that and appeal was preferred by the petitioner against the order of the learned single judge merely directing for exchange of affidavits being met 56 of 2025. The Honorable Division Bench, by its order dated 30th July 2025, has disposed of at the time of disposing, the appeal has also disposed of the present writ petition. She files a copy of the order of Honorable Division Bench passed in Mat 56 of 2025. In view of such submissions, the writ petition being WP 1327 of 2025 stands disposed of.
Milord, in that case, Milord, can it be tomorrow, Milord? I am from the private respondent.
What is this case?
Milord, they are challenging an NOC granted by the district magistrate in my favor for operating a petroleum retail outlet. The NOC is under the petroleum rules. So they have challenged the land document, the NOC granted by the Panchayat Pradhan, everything. That is the scope of the writ petition. So that we have a response to everything, that whatever has been granted was in accordance with law.
Okay.
Now it is only a private dispute between me and him with regard to the land, and this is, Milord, a counterblast to that.
Okay. State.
Your Lordship, I am for the state. Your Lordship, in this matter, the disputed led under sub judice. There is two matter pending before the lower court. One is title suit, one is
Title suit is pending.
partition suit.
Both are pending.
Yes.
Both are pending.
They are co-sharers. You
They are
and
co-sharers.
Co-sharers.
their challenge is that on the co-sharership land, this cannot be made.
Yes.
Even tomorrow, not today. Tomorrow.
Thank you so much. Sir, can it be accommodated on Monday? Subject to Lordship's convenience.
Monday to kada hoche. Monday to Friday your problem.
Tuesday then, Milord. Actually, Milord, the division bench has fixed two matters.
Monday.
Monday.
Much obliged, Your Lord.
25. Hello, item number 25. The last occasion direction is given to after staff of the state to file a report in the form of affidavit.
I am on the above the petition.
Kindly, Milord, grant us time.
The matter on 17 June 2026.
Why?
Conducting appropriate appearing the same day on the matter.
Who will appear?
SM Obidullah.
This is a transfer. This is a transfer.
The compassionate appointment, Milord.
Passionate appointment.
The last occasion direction was given to file a report in the form of affidavit.
This is pending or compassionate has been rejected.
Milord, it was rejected thrice, Milord.
Thrice?
Yes, Milord. Twice or thrice, Milord, I have to go through, Milord. As the report is pending, Milord, that I have not gone through properly, Milord.
Mr. Ronjit Ghosh, learned advocate representing the state respondent seeks extension of time to file report. Let such report be filed by a returnable date. Release this matter on 18th.
Milord, kindly 2 weeks, Milord, I think. Milord, we'll have to collect the report, Milord, thereafter file to affidavit, Milord. It needs much time, Milord. We have to find out this person also.
Extension of time of 2 weeks to file report. let such a report be filed within a period of 2 weeks, exception if any filed within a week thereafter. Liberty is granted to the parties to mention after expiry of the aforementioned period.
Yet, Your Lordship.
My lords, I'm led by learned AAG. He's engaged in another courtroom, my lords. So, kindly makes it not today or আসতে পারবে না মনে হয় এই কোর্টের মামলাও শেষ হয়ে গেছে let him say what he says.
This is the another matter cause of yesterday's matter which has been heard my lordship. I want the investigation to be my lordship. The investigation টা আমি
ঠিক আছে না এখানে
এই একটা কাল দিয়েছে মাত্র ওটা আমি কম্পেনসেশন শুনতে চেয়েছিলাম আমরা ফাইল করেছি আমি আমার আমার যাওয়া আছে সিআইডি থেকে এটাকে সিপিআইতে দেওয়া হোক কারণ সিআইডি চার্জশিট ফাইল করে দিয়েছে যেটা লাস্ট ডিভিশন বেঞ্চের অর্ডার ছিল কিন্তু সেই ফাইলটা ওই একই ব্যক্তি পেয়েছে যে ব্যক্তির একবার ছিল আর ডিভিশন বেঞ্চ সেটার উপর অ্যাগ্রি করে সেটাকে সিআইডি কে দিয়েছে আর মাই লর্ডশিপ এখানে আরো চার্জশিটে অনেক কিছু দেওয়া আছে যেটা রেজিস্টার অনেক কিছু বলা আছে এখানে অ্যাকর্ডিং টু মিস্টেজেস রিপোর্ট 2954 বেল বন্ডস ফার্নিশ হয়েছে যেটা থেকে আলিপুরদুয়ার কোর্ট অফিসার ওনাদেরকে ফার্নিশ করেছে অনলি 394 বেল যেটাকে ভেরিফাই করা হয়েছে বা রেজিস্টার করা হয়নি আর সঙ্গে যাকে চার্জশিট করা হয়েছে মাই লর্ডশিপ ওনাকে ওনার সিগনেচারের সাথে ম্যাচ হয়নি যে ফোর্জারি সিগনেচার গুলো কিন্তু ওনাকে রাখা হয়েছে কারণ উনি স্ট্যান্ডিং অ্যাডভোকেট এবং কি জামিননামা বেল বন্ডস গুলো উনি ভেরিফাই করেছেন অ্যাকিউজড পারসনের হয়ে সেই ক্ষেত্রে ওনাকে চার্জশিট করা হয়েছে কিন্তু ওরকমই আরো 3 জন অ্যাডভোকেট আছে যেটা আমি তথ্য পেয়েছি এই রেকর্ড থেকে পেয়েছি যেটা এসআইটি ইনভেস্টিগেশন করে বের করেছিল কিন্তু ওনাদের এখানে চার্জশিটেড করা হয়নি এখানে অনেক কিছুই হাইড করা হচ্ছে মাই লর্ডশিপ আর ওনারা আমাদের উপরে ডেইলি লাইফ টর্চার করছে মাই লর্ডশিপ যাকে চার্জশিট করা হয়েছে সে বেলে আছে এই হাইকোর্ট থেকে বেল নিয়েছে বাট দ্য বেল গ্রান্টেড ইন ফলস গ্রাউন্ডস which I challenged before the division bench but division bench not single bench but the bail has been granted by Justice Arijit Banerjee and I in person for lack of knowledge I mentioned that matter before Justice Devanshu Ashok and he says that the coordinate bench can't cancel the bail bonds according to Supreme Court judgment. That's why that matter has been disposed of. But my lordship, there is many things which I want to submit in this petition and my prayer is there is lack of investigation, my lordship. No investigation has been comment according to the order. My lordship, please come to page number 2, my lordship. My lordship 23. Page number 23. My lordship, this is the Justice Rajshekar Martha's order in my lordship, point number 7, my lordship. Point number 7, the charges filed by the police has only one person as an accused, that is Koshipoli advocate. And for that, my lordship, in next page, 9 number point says that SIT has hesitation to do the investigation which they revealed before the court, my lordship. And for that only the investigation has been given to CID. And my lordship,
Yes.
my lordship, thereafter, there has been written in my lordship point number 14. My lordship, point number 14, page number 25. My lordship, the investigating officers of the CID shall carefully go through the directions issued by this court from time to time and carry out the same in letter and spirit. My lordship, according to that, nothing has been done, my lordship. My lordship, this is an order passed in May. Another order is passed on 29th January 2025, annexed in page number 32, my lordship. That order is first order, which passed by Justice Jamal. That order also not been complied, my lordship. My lordship, the FIR, which has been ordered by division bench to register, my lordship, carries two accused person and just we don't know, my lordship. My father has registered, my lordship, the FIR I bought today, my lordship. My lordship, there is two accused person against which the FIR lodged, but they registered only one accused person, that is Kaushik Bonik. But in the name of Virendranath Bonik, the land has been transferred by the forced signatures. That person has not been registered in FIR also and not been charged also, my lordship. My lordship, they trying to hide this, my lordship.
Ask for time, na?
So it's not specific on the.
Yes. So what is she asking for?
I don't know in this what was she asking for.
Whom is she representing?
Her father.
She cannot. This.
All the papers will be revealed, my lordship. Everything will be revealed that how this process, my lordship, capacity has been enhanced. That is also
Well, what is the report?
filed by the
Prefix also it's I gave it copy, right? We could go ahead.
My lord, who is she representing? Who is she representing, my lord? I don't know.
She is a petitioner.
There are three petitioners, my lord. Sukhendra Bonik, Papia Bonik, Sunandita Bonik.
She is Sunandita Bonik.
So, my lord, then three is in person and 1 and 2 are not been represented.
my lordship, they give me a special power of
How is that possible? I put this question to myself, my lord. Representation in court has to be through a lawyer. Power of attorney, my limited, my lord, knowledge says cannot empower any individual other than a person who has a enrollment with the bar council can represent. Representative capacity in that manner cannot be done, my lord. Subject to correction, my lord. So if the person who is appearing in person, my lord, clarifies this position before your lordship, then my lord, we can proceed with that. And even then, my lord, I think the learned assistant additional advocate general is appearing in this manner. In this matter, my lord, he's
When is the
on
other
his
matter
legs.
coming up? The other matter, yesterday's matter is fixed on
my lordship, tomorrow.
tomorrow.
Right.
देखो ना service हो चुके ना देखो ना. And my lord will kindly, my lord, keep that point in mind, my lord. Then the other petitioner's name will possibly get expunged since they are not been represented, my lord. In person one can do, but representative capacity possibly, my lord. I'll also check up the law, my lord.
On the last, that is on 13th April, she appeared in person.
Yes, today also she is appearing in person.
My father has some work, that's why you can't.
That cannot be done, my lord. There is a procedure in court, my lord knows. There are 5 petitioners, my lord. One petitioner comes and says that others are in.
Upon the state.
This has been served, my lord. The rest we will check out.
The other writ petition, which was moved yesterday,
Okay.
she claims that there has been some threat and all.
Very well,
So
my
she
lord.
has prayed, they have prayed for
Yes.
compensation.
Yes.
In this petition, they are agreed by the charge sheet that has been submitted by the CID against one person, but they have other allegations against the person.
Very well, my lord.
কালকের কপি আপনি দিয়েছেন?
My lordship, department.
My lord, can I make one humble prayer, my lord, on behalf of my learned additional advocate general, my lord? Can it be taken up on Tuesday or Wednesday as per your lordship convenience, my lord, so that we can also ascertain the copies which have been served and all? Tomorrow, possibly, my lord, we not be able to do that. And we'll also check up that law, my lord, which the objection which I has just taken up.
Okay. No, the yesterday's matter is coming up tomorrow.
Tomorrow. Very well, my lord. Then that I cannot disturb right now.
Because the allegations has been raised in the writ petition. I suppose by verbal submission, this cannot be resolved because a report has to be there
Very
from
well,
the
my
side.
lord.
So, এটাকে not today করছি। এটা কালকে আবার লিস্টে থাকবে আপনার আগের মামলার সাথে, ঠিক আছে? আর গতকাল যে
My father will request.
মিস্টার মিশ্রাকে কপিটা সার্ভিস করেছেন?
I've served to the state which is at.
All surveys, my lord, we have requested everybody to serve it upon the office of the legal remembrancer. This was served, so we have received. It possibly was there. We will find, well, we will do that. My learned friend is there along with Mr. Mishra in the other case also. They will be there, my lord.
এটা কালকে লিস্ট করুন।
Very well. A simple not today will do, my lord. Grateful.
এটা ওনার ফিরত দিয়ে।
Not today, just a simple not today.
দেখি না।
Lordship.
None appears on behalf of the petitioner.
No, Lordship, am I audible to your Lordship?
Nor any accommodation has been sought for.
Lordship, am I audible to your
On the
Lordship?
last occasion, that is on 11th February 2026, the petitioners failed to appear.
Lordship, I am not audible to your
In view of
Lordship.
the above, the writ petition.
Lordship, I am for the petitioner. I am appearing for the petitioner.
Oh,
Lordship, in this matter, Lordship, am I audible to your Lordship? Lordship, am I audible to your Lordship?
Mr.
I am
Dhar, you
appearing for
unmute yourself.
Now am I audible, Lordship? I have already unmuted myself. I have already unmuted myself, Lordship. Lordship, today he is suffering from pox. That's why he is not.
Sir, you
appeared in the
unmute
court.
yourself.
I have unmuted myself, Lordship, in my computer.
Huh? Telephone number.
Lordship, now am
Mr.
I
Dhar, please
audible?
rejoin.
Lordship, I am rejoining.
আচ্ছা, কি করবো, পাসবুক করবো? একটু পরে দেখো। Next.
43. It's Union of India with safety authorities rather than.
Who will represent? Mr. Bisra will represent?
No, not this. Yes. Probably Mr. Agarwal. Agarwal.
He's not present today.
Okay.
Mr. Vikramaditya Ghosh, learned advocate for the petitioner, seeks accommodation. The respondent CGST is not represented. Release this matter on Monday then. Monday কালকে কেমন আছে? অনেক আছে। এই প্রপার দিনে দিতে হবে না। Monday কি থাক? Monday কি থাক? দেখবো Monday কি। Learned advocate for the petition that will give a notice. Learned advocate for CGST respondents intimating the next day. দেখো না 27 টাকা
27. Lordship, I am for the petition. Lordship, now I am audible.
Same problem.
Number
am I
কি
audible?
করছো ওখানে? ওনাকে ফোন করে বলো না। ওনাকে ফোন করে বলো নট টুডে করছি কালকে আসবে। Mr. Dhar, you are not audible.
Lordship, then kindly make it on
No.
next Tuesday.
No, now you are audible.
Lordship, this
What is
matter
this?
this is a matter relates to initiation of acquisition proceedings on the facts and circumstances that the land of the petitioner has been vested and vesting order has been quashed by the Honorable High Court. Until then, in spite of that, the land is holding by the state government. Now, by an order dated 11th February 2026, the Honorable Court has been pleased to pass an order by directing the respondent to submit report. As yet, no report is submitted. So let them direct to submit a report on the as desired by the Honorable Court, and matter can be heard
Your
on
Lord-
next Tuesday.
Your Lordship, we do not have got the copy of the same. Your Lordship, kindly give us some time so that the brief. Yes.
Who is here? Who is your learned advocate in Jalpaiguri bench?
See, Mr. Ankon Mitro, he is from today.
Ask
He is
him to
suffering.
serve.
Lordship, I will
You
serve.
serve a copy of the writ petition upon the learned advocate for the state respondents.
Gratefully, Lordship.
Lordship, shall I
Ask him.
serve it upon the additional government leader?
Elad,
In the-
sir, kindly serve in
in
the
the
office of
office
the legal remembrance, sir.
Miss Isha Acharya, learned advocate representing state respondents, submits that the copy of the writ petition and its annexures be served upon the state. Stop. She seeks extension of time to file report in terms of order dated 11th February 2026. Mr. Devashish Devabruto Dhar, learned advocate, appearing for the petitioner through virtual mode, undertakes to serve the copy upon the state respondents. Let such a report in the report be filed by the state respondents within a period of 2 weeks.
Great. Subsequent to the service of the petition, your lordship, because
Within a period of 2 weeks.
Sir, I will
Stop.
again, sir.
In the meantime, learned advocate for the petitioner shall serve the copy of the writ petition upon the learned advocate for the state.
deeply obliged, your lordship.
Liberty is
Matter
granted
may
to
be
the
appeared-
petitioner.
Lordship.
Liberty is granted to the petitioner to mention after expiry of the aforementioned period.
Deeply obliged,
Deeply
your lordship.
obliged.
Grateful, your lordship.
Deeply obliged, Lordship.
Yes, thank you. So,
44.
Your lordship, learned AAG is leading in this matter. Your lordship kindly gives a date or time. Not today, your lordship.
your reply you have filed?
Filed reply. Basically, my lord, the state is by filing the report, the state has already supported my contention, my lord. My lord, what happened, lordship? The petitioner applied for the fair price shop license in the Matavanga subdivision. So, my lord, the notification says that the person who will be the selected candidate, there, my lord, he should not have any other license, or his near relative should not have any other license. Otherwise, he will not be eligible for the for getting the license. Well, what happened? The person who has been selected who has been given license, his sister's husband has already license. And as per the notification, sister's spouse is considered as near relative. So therefore, the private respondent is not entitled because his sister's husband has already fair price shop license. Now, my lord, my lord, initially, my lord, filed a writ petition. Your lordship, if your lordship comes to the order of the
Private respondent have been served.
some number of occasions he appeared, but now he, my lord,
It's not appearing.
last few occasions it did not appear. Your lordships, if your lordships kindly see the order of the order page 59 of my petition, lordship, everything will be clear.
Page
59.
Your lordship, instruction had to be received, your lordship. In this matter,
By before, they are supporting me. How they are supporting me, I am explaining to your lordship.
kindly, yes,
Learned Additional Advocate General, Assistant Additional Advocate General is appearing. now.
kindly, your lordship.
I do not know about the brief, my lord. So, or else I would have tried to assist your lordship. Kindly takes it up tomorrow, my lord. What I heard from my learned friend one day would not, my lord, make much of a difference to my learned friend's client.
Okay. Tomorrow.
Great.
Grateful.
Not today. A notification. Notification has been annexed.
Notification, I mean, annexed, everything is there.
Read it. You
Not
have to
today.
Read it. There is a.
Lordship, I am from the petitioner. I have filed a substitution petition.
There was a direction upon the state to file an affidavit in opposition. It is ready, my lord. I found it in the brief.
No.
I'm serving a copy upon my learned senior friend.
This is legal years or
Lordship,
who has died?
died petitioner number 4. He is the mother of all these petitioners, and also another petitioner named as Chandal Roy. But Chandan Roy is not interested to deal with this petition. So we have prayed, let the substitution be allowed and the Chandan Roy, the married pro forma respondent number 7.
7. And who will be the substituted
It's within period, the
petitioners are 4 to 11. 4 to 11 will be added as a petitioner in place of 4.
in 4 has died. She is the mother of all other petitioners. Of all other petitioners. And another petitioner, that is
Wait.
Chandan. Chandan is not interested. All
Petitioner
these
number.
parties are already on record except Chandan.
Okay. The person who has died is Leela Roy. Leela Roy has died.
Right.
Leela Roy's legal years are
All these
oh.
1 to 11. All.
Leela Roy is petition number 4. Then how you write 1 to 11 are the legal years of Leela Roy?
Leela Roy died.
So 1 to 11, 4 is also included. How do you write that? Leela Roy petition number 4 has left read petitions number 1 to 11 as legal years.
I may be permitted to
Who are the legal years then?
legal years, these except 4, all are the legal years.
See paragraph number 3.
3, yes.
This is a wrong statement. This has to be accepting 4. Accepting 4. 1, 2, 3 and 5 to 11. Seven is not coming with you.
7 is not coming.
Yes, Mr. Bhattacharya.
Not
We are not able to find that copy which I have requested my learned friend to. But if it is otherwise on time, then there is
Within
no
time.
impediment.
When did she die?
She died in 12 February 2026 and we have filed this petition on
30th March. Date certificate?
Death certificate and in page number
10.
10. Yes.
No new persons will be added, what I have understood, all are there only.
All are there.
Chandan was not the petitioner in earlier petition. Chandan, as being the legal heir,
Will be added.
will be added.
It's a formal in nature, man.
Can 1 of 2026 affidavit of service filed on behalf of the petitioner is taken on record? Or can 1 of 2026. This is an application praying for deleting the name of petitioner number 4 in the cause title and allow the petition for substitution, adding the son of the deceased, namely Chandan Roy, as a respondent, pro forma respondent number 7. Mr. Suvensu, learned advocate, appearing for the petitioner, submits that all the legal years of deceased Srimati Leela Roy, petition number 4, are already on record, excepting one son, namely Chandan Roy. He seeks that said Chandan Roy be added as respondent number 7 in the array of parties. Mr. Kunaljit Bhattacharya, learned additional government pleader, leaves the matter to the discretion of the court. আচ্ছা ওনার সাবমিশনে বলো the application has been for substitution has been filed within time. ওনার সাবমিশন petitioner submission has been filed within time. From annexure R1 para. From annexure R1, it is found that petition number 4 Leela Roy has expired by annexure R1. No? Annexure R1 death certificate. Death certificate. Died on 12 February 2026. All the legal years are already on record of the deceased as petitioners. Excepting Chandan Roy. In view of submissions advanced on behalf of the petitioner, let the name of Chandan Roy be incorporated/substituted as respondent number 7 in the array of respondents. The death of petition number 4, Leela Roy, be recorded in the cause title of the writ petition. The application being Can 1 of 2026 stands disposed of. Give a copy to Mr. Bhattacharya.
Yes, yes, my lord. I'll take a copy.
Affidavit, writ petition heading on WPA 1516 of 2024. Affidavit in opposition filed on behalf of state respond number 5 is taken on record, copy served. আচ্ছা ওখানে একটা ডিরেকশন দিন Learned advocate on record for the petitioner is directed to serve copy of the writ petition and its annexure upon the added respondent number 7 and file affidavit of service on the returnable date. Please this matter before the next available. You reply, you will file?
Reply দেবেন তো? Clear?
You will file a reply?
Yes, we will file.
A reply যেখানে writ petitioner heading করেছেন reply to the affidavit in opposition of state respondent filed by the petitioner within a period of 2 weeks.
Grateful, man.
এখানে RTA আছে RTA টা আছে
Hello, I'm praying for a short passover because in this matter, Ms. Supriya Singh and Ms. Rajni Singh Dev is appearing, but they are on their legs, Your Lordship. I'm praying for a short passover, Your Lordship, in this matter. Challenging the RTI. Brief meaning of this. अच्छा. Yuvraj se ben benim sorry.
Yes.
I am not the briefed counsel, your lordship, but from here it shows that they have already preferred the first appeal and subsequently the second appeal has been preferred by the petitioner, your lordship. In that regard, the learned counsel, Miss Supriya Singh, is leading, but she is on her legs in another matter, your lordship. So kindly make it, kindly keep this matter on Monday so that she can come with proper instruction. Because they have already preferred the appeal, your lordship, and the second appeal. But from the record, I could not find whether they had preferred the second appeal, your lordship, as I got the copy from my learned colleague.
Second appeal you have preferred.
Yes, from the record, your lordship, from the date,
You-
from the short list of dates, that is 19/12/2024, they had preferred the
Second appeal.
second appeal. But regarding the same, I couldn't find the particulars of the second appeal from the brief, your lordship. So I need to go through it, or as she is the leading counsel, so I am not briefed in this matter, your lordship. In that regards,
There was a direction to file affidavit in opposition.
there's a direction. Yeah. Previous order, I do not know. I'm not. I think it was 2024-25 matter.
Your lordship, kindly fix it for tomorrow.
She wouldn't be there.
No, I'll take the brief and take it.
Affidavit of position and direction.
Direction.
Your lordship, I should be candid before your lordship that tomorrow also Miss Singh would not be available. So, and if there was a direction from the coordinate bench to file affidavit, your lordship, that has to be abided by the state, your lordship. In that regard, I would pray for extension of time to file the affidavit in opposition, your lordship.
Give copy.
I don't have any copy.
Yes, yes. Thank you.
Yes.
Amini, she is there. I'm not there.
Isha Acharya, learned advocate for the state respondents, seeks extension of time to file affidavit in opposition in terms of order dated 18 January 2026. Let such affidavit in opposition be filed within a period of 2 weeks. A reply, if any, be filed within a week thereafter. Learned advocate for the petitioner is directed to serve copy of the writ petition and its annexures upon learned advocate for the state respondents. Liberty is granted to the parties to mention after expiry of the aforesaid period. After 3 weeks, you mention before the court, if the bench is 2 weeks to file the opposition, reply they will file 1 week.
Yes, yes, yes.
What is this matter about? When did you retire? When did you retire? Hmm? $25. Requisite wasn't for 2 years. Later completed training approved in 95. How many years you did not attend the school? How many days? Correct.
After considering the representation issued a rejoining letter in the itself that mind the 2 weeks in 2012. And below the sir has made several recommendations for the due salary.
But the period which you have not attended the school, why they will pay salary?
Subsequently, these are joined in 2012. Then he has started to attend the school.
Your absence during that period has been condoned.
Then in 2015, we got another video.
Hmm.
In the application, honorable Gora granted the leave the petitioner.
For?
The period of 2010 to 20.
Then leave was granted for the period into okay. Do what sure. That in the Where is the order by dint of which the leave was granted? In paragraph 10 of your writ petition, in paragraph number 10 of your writ petition, you say that a representation was made before the Commissioner of School Education and the leave was granted for the period 1st January 2010 to 24th April 2012. Where is that order? 29. No, 29 is your application, but this has been allowed. Leave has been granted. Where is that order granting leave? You file a report.
It's on page 24.
I'm asking you, in 10 you say that the leave has been granted. Where is that order of the Commissioner granting leave from 1st January 2010 to 24th April 2012? You give a copy to the other side. You have received the copy? Copy. Learner Advocate for State submits that seeks extension of time to file report in terms of order dated 27 November 2025. He also submits that the copy of the writ petition and its annexures be served upon him. Learned Advocate for the petitioner is directed to serve copy of the writ petition and annexures upon Learned Advocate for the state respondents. Let a report be filed by the state respondents within a period of 2 weeks, exception if any, be filed within a period of 1 week thereof. Liberty to mention after expiry of the aforesaid. এটা পাস ওভারেটে কিছু হলো না? তাহলে নট টুডে হবে? Yes? Mr. Kundu, not today. Mr. Sunit Roy, he has not appeared online. Okay, tomorrow we'll see. Oh.
By that, we'll also receive our instructions.
It's all right then.